But yeah,
we're good to go.
we got a lot of good stuff up there. Okay, let's call to order this January 2025. It'll probably take me till 2026 to figure out that I'm in 2025. Meeting of the Albany County Planning and Zoning Board. We'll start with a roll call. Hanning.
Here.
Mr. Platt. I see your smiling face. You need to unmute yourself if you want to talk to us.
Yep, he muted himself. He was unmuted.
Oh, okay, well, we can see him there. Ms. Kokornik is out, and Ms. Van David.
Present.
And Hinckley present, so we got 4 out of 5. That's a quorum, and we will proceed. I'd just start out with noting the reappointment of Commissioners Platt and Van David for an additional 3-year term. Thank you for the vote of confidence from the county commissioners. We have a new county commissioner as of last November, Mr. Hoff, who had his first meeting just yesterday. I've invited him to talk to me or any of us about just what we're doing or where we're going. I haven't heard back from him on that. And then yesterday, they also assigned us a new liaison with the county commission, and that's Terry Jones. So I guess she's not here today, but we may see her in times to come. So that's where we are as far as personnel. Let's look at the agenda. Looked good to me. Anybody want to add or subtract?
Yes.
Okay, Mr. Rose.
So we need to take the Arthur Fork subdivision off of the agenda.
Oh, okay. Because
The applicant pulled it. They are just going to sell the entire parcel.
Go.
And then we need to add, I was thinking at C of staff updates, add 2025 meeting dates and times.
Okay. 2025 meetings. Yeah, let's leave Arthur on just in the spirit of discussion. If somebody had a chance to look through the application, I know we have.
Right.
There might be an opportunity to kick that around a little bit. We're not getting decisions, obviously, but we might take the opportunity for those who have reviewed it to. I had just a couple of informational questions. Okay, with that addition, is there a motion to approve the agenda as amended?
So moved, Mr. Chair. I second.
Second, further discussion?
Well, I
Yeah.
guess Michael could.
Yeah, Michael, keep it rolling.
Jump in there.
Please do this.
All right, all in favor of that motion, say aye.
Aye.
Aye. Opposed, same sign. Mr. Platt's looking kind of stoic there.
We said aye.
Oh, okay. Now, then we can bring this to the minutes. I would,
Hey, Michael, we can't hear you.
if you're talking, we can't hear you.
Nope.
He was on.
Nope.
It's not showing up as.
Is muted.
But
Nope.
Is our volume on?
You'll have to
it's,
resort
I
to
can make it higher. You
semaphores.
want me to turn the volume higher?
Yeah, sure, try it.
Okay.
Somebody's muted somewhere.
Michael's muted right now.
At his end or ours?
On his end.
There, now try Michael.
Nope.
Uh-huh.
Oh, I know, there's so many different settings on which computer. you're
Yeah,
on.
which
Oh my
channel
God,
do you
this
prefer?
makes me crazy.
Are we now too high or is it okay?
Oh, we don't know.
No, I mean, I'm asking.
I'm guessing it's at Michael's end. I know I have that problem when I'm on a different computer and you have to find the little
Turn it
software
up.
switch. And
Hey, Michael, was there a number that you could call into on that email?
I don't know, and
Can you hear us, Michael? Okay. Well, I guess you can jump up and down if you don't like what we're saying. Can you try that phone number? I guess all right, he's gonna go to try.
He's gonna get his phone. Maybe he can just use the reactions to do it.
Yeah, there you go. They have a lot of emojis now. You can cry or you can smoke come out your ears. Will he come through if he's just phoning?
We'll come through, but Michael, your phone in is, yep, there we go.
Okay.
Unmute your phone connection.
That's looking like progress.
Yeah, his phone is.
Okay, there he's
Gotta
got.
try it.
Can you hear me now?
Yeah.
Success.
Okay,
Old fashioned telephone.
there you go. Cans on strings, that's what we'll be reduced to. Okay, so we're all back in business. We're looking at the minutes, and just as a kind of a preview of coming attractions, Mr. Platt has been working with staff on minutes and talking to Mr. Ayers and some of the other officials in some of the other counties even, and has got some thoughts for us. He and I discussed it briefly and thought it might be easier to have that discussion with him here. So we'll just understand, we'll have a more comprehensive look at minutes and maybe develop a new program going forward. We'll have that on the February agenda. If you guys could put that on for February, that'd be good. As far as right now, I guess my suggestion, and we can discuss that further, would be that all the editorial kinds of things, I assume that Mr. Williams would appreciate, just as anybody would, just, if I got the spelling wrong or the spell checker used the wrong kind of there, I'd say we can just hand those to him and leave it up to his good devices of whether to accept those or not. Those aren't the kind of thing that we probably need to run around through us. So let's confine our remark, if that's acceptable, let's confine our review of the minutes at this meeting to just, if there are any just flat out factual errors, something that's just plain wrong, would be the things that we could opine on rather than how something was said. Now, I don't know if you saw my last email on your minutes.
Mm-hmm.
Did that make sense?
Mm-hmm.
Okay, so just to quickly bring you into that discussion, Mr. David had suggested.
Ooh, it's gonna get some.
Okay, so you need to turn off something, Michael, so we don't get the feedback going around.
He just muted himself.
Maybe just settle for the audio and skip the video. All right, that was just that one little incident. Right, what I was going to say is one of the things that was kind of contorted in the minutes wasn't really in the minutes. It was a quote from the amendment itself. So there again, my suggestion was that isn't a minutes correction. It's a correction to the amendment, and that will be on our agenda for February. And so that would be the appropriate time to run all that through. If that's acceptable.
It is. If you remember, during the meeting, I requested edits on that paragraph that was one sentence, and it was too difficult to do on the spot, so I promised to look at it later. And
Oh, okay.
and that's why I put it into the minutes, but it should be the amendment, changes to the amendment and discussed when we.
Yeah, we can bring your statement forward when the amendments come forward.
Yeah.
It was just basically breaking that sentence into three.
Yeah. Okay, no, that sounds good, because that's on our agenda for February, right? We'll have then had our 30-day period, and I think we schedule it for a public hearing. Okay. The only, what I would call an error was cut and paste. It's the December meeting minutes that say the next meeting's in December. Maybe you caught that.
Oh, okay.
It's there at the very end.
Sure.
Anybody else? Okay, with that tiny change, I'll take a motion to approve the minutes.
I move that we approve the minutes from the December 11 meeting.
And I will second.
And it being moved and seconded, further discussion, all in favor, say aye.
Aye.
Aye. And you can just give us the thumbs up, Michael, if it's too hard to get all the buttons pushed. Disclosures, Ms. Hanning,
None.
Mr. Platt. Miss,
No, I froze.
oh, I'm seeing a no, that works. Ms. Van David,
None.
thankfully I have nothing to report in that regard. Okay, that moves us to public applications. Just to review the procedure, we'll start with a report from the staff, invite the applicant to give us any comments they would like or to stand for questions if they so choose. Then we'll have a public hearing where we'll invite anybody who wants to, either in person or on the Zoom, to give us their 2 bits worth. If you're gonna give us a statement, tell us who you are, where you live, so we can keep you in the record. Confine yourself to the topic, and we'll try to keep those reasonably bounded if we have too many people wanting to talk. Then we'll take a formal motion to close the public hearing and move on to our board discussion or commission discussion of how to dispose of it. Okay. First one up is the Taylor conditional use in Centennial, which, gosh, anytime the word Centennial comes up, we kind of want to run for cover, but here we are, Mr. Garch.
Yeah, Mr. Chairman, Commissioners. So the applicants for this conditional use are David and Susan Taylor. And their property is located at 2768 Highway 130 in Centennial.
Yeah.
Currently there's a restaurant on the property, and also the residents that they're applying for conditional use for. The property is zoned commercial, and so within the commercial zone, it requires a conditional use if you'd like to put a residence on the property. You guys probably know Centennial. It's very mixed in its uses, especially along the highway. There are a lot of residential, commercial, and a mix of those in this area. Water and sewer is from the Centennial Water and Sewer District. Sounds like they've already got their water and sewer hooked up. We did receive a letter from the Water and Sewer District. All in all, there wasn't any significant impacts to the area that weren't, or, everything was addressed, all the impacts, and staff's asking for approval. With that, I mean, we could discuss the letter too, if that's something you'd like to do. But at this point, their recommendation is approval.
Okay, I had a few questions, some just for our information. Others, Sanning, you want to start out, or you?
Sure. I have a few questions. Thank you, Mr. Gersh. So I guess I just want to get some clarification about different things in the application.
Sure.
There was a statement by the applicant that there's always been a residence at this location since 1932. Is that the same residence that we're talking about now?
No, this is a new building that's been put on the property.
Okay. Can you fill me in on the vacation of the right of way that occurred with the county commissioners?
Yeah, so a portion of First Street, I believe, was vacated. So that basically everything is, yeah, they moved it out. How far was that moved out? Like 40 feet? 35 feet. So they moved that onto First Street, so that back side of the property, that whole kind of block area was vacated by commissioners.
So there aren't any utilities there that are impacted by that?
Not that I'm aware of. I mean, there's still right of way that exists for the road and whatnot. But I wasn't involved with the vacation process, so I guess I can't really speak
Do
to
you know
that.
when that occurred?
The vacation?
Yeah.
I think that occurred in the summer, right?
I'm not sure about this one, but Commissioner Yang, just so you're aware. Centennial the way it was platted and the way it was built, two totally different things.
Right, yeah.
So-
I got that impression.
So, I mean, there have been, over the past 3 years, I know Jennifer, my colleague, has done multiple of these. Just so, because people, you know, the properties and structures that they purchase are usually in a right of way. So it's really just, you know, the county kind of going back and helping dedications match reality.
Okay, thanks. Another thing in the application that I was confused about was something along the lines of that the house was already grandfathered in and that a variance expired 2 years ago.
That was something that the applicant, I don't follow.
You don't
that.
give variances, right?
Right.
You'll get a turn, don't worry.
Yeah, I guess I don't know.
The original building, it had an upstairs and people lived in it. And that's what we thought.
That,
Be grandfathered in.
that was,
Residents.
that,
But
resident
they-
was grandfathered
But
in.
they said it was too
Too late,
too long.
too long between someone living there and someone not. So then we had
Oh,
to
okay.
start
It was a discontinued
over
use.
for zoning.
Okay, all right, we'll come back to you guys for your own
Thanks,
point to the podium.
I get that now. I mean, that it was a discontinued use that wouldn't have been allowed without. I'm
Correct.
Thinking of the right term in the zoning ordinance, but, let's see, one thing that the county engineer brought up about historic drainage corridors. Is that anything that is of concern with the new building?
Are you white
I guess my
county?
notes are not that the county engineer brought that up, that I'm wondering, did the county engineer weigh in on that? I think that was a comment from the highway department
Yes.
about it.
Yes.
And I just wondered if you got any feedback from anybody, like the county engineer.
Well, where the building is on the back side of the building, so it shouldn't impact the highway on the other side. It's along First Street more than it is along the highway. And what we receive from, I mean, that's, they put this in everything. I mean, they want, if there is drainage that's going to change, they always say that, you know, it needs to be at historic levels.
Right.
But the county engineer didn't weigh in.
It's a standard language from the highway department.
Yes.
Is there a zoning certificate for this house?
Not at this time. If the conditional use is approved, then it will be approved.
Okay. I guess, one of the questions I have about findings for approval are whether or not, you know, oh, where is it? Sorry. It's big B, little b. That the proposed conditional use shall not harm the public health, safety, and welfare of the community. And I guess I wanted to get your take on is moving forward on building a building without having gone through the proper regulatory approach. Does that do harm to the community? Just because from my personal past experience using like penalty policies for regulatory infractions, it was one of the things that would be looked at was what was the general harm to the public by having an entity not follow the regulations. And I just wondered is that anything you guys have discussed?
No, I mean, when someone comes to our office and they've done something without a permit or whatever, I mean, the first option has always been, let's see if we can get a permit. Even with some of the past projects we've had, that was the first thing we did before we tried to enforce other options. But I don't know if we've had like a huge discussion on that, but I guess that's how we've always went about it. It's like, let's see if we can get a permit and then we'll worry about other options afterwards. That is.
I agree that my observation is you guys are usually trying to figure out how to take care of what's wrong and get it into the regulations.
Right.
So thanks, that's my list of questions. Thank you.
It's been David.
Yeah, so most of the question that Moira had, my question relate to the water and sewage district
Right.
and the opposition. Even the letter you sent this afternoon,
You just,
I just wanted to know, do we have the ability to override a local jurisdiction?
so, I would say that we're two different entities worrying about two different things. What we're worrying about is the conditional use for the home on the property. What the water and sewer district is worrying about is their water and sewer, the lines and the hookups there. I would say too, that the first letter we received, from a past member, that was more of a, we don't approve of this application. The one we received today, or actually, I think I got it last week and I just found it today because I was going through everything else after the holidays, but, they basically say that, this is what it says in our rules. As it concerns the conditional use, we're not taking we're not saying yay or nay. That's up to you guys, basically. So they've really left it up to us, but they did just want to explain their rules to us. So it doesn't, to me, they're not in opposition to the conditional use itself. But they want to make sure that they get their issues taken care of, which it sounds like they will do on their own. But that's how I read the letter today.
Mr.
Mr. Chair. And Commissioner Ben David, to your question, planning and zoning's recommendation has to be specifically tied to the findings necessary for approval. The only finding necessary for approval that touches on utilities essentially would be that adequate public services are available for the proposed conditional use without creating an undue financial burden on the county. The way that is written is somewhat odd, and it really has to do with, is there public service availability such that it won't financially burden the county, not whether the applicant has complied with any applicable rules or regulations of a utility provider. So I do not see a finding necessary for approval which can be tied to that letter, or under which that letter could be addressed.
Yeah, to follow up on that briefly, if I may, and I had identified that also as the possible nexus there. So, and I kind of stopped at adequate public services are available, and what the financial burden part is. If it were clear that there were no public services for whatever reasons, would we be remiss in making the conditional use approval?
If there were none available.
Okay, because availability is both a physical and a legal thing.
But it's that qualifying language, without creating an undue financial burden on the county. I think that really narrows the scope of that previous language.
Matt, is that even in a conditional use application?
It's in the zoning change.
Yeah, we're doing a conditional use.
Yeah, I'm reading it.
It's
That adequate.
It's big B, little c.
We're reading from the staff report. Big B, little little c. Is that?
Oh, is it it's above the other findings, right?
Yeah.
Yeah, sorry.
No, that was one that I asked myself that same jurisdictional question that my colleagues have of, it sounds like there's a meaty dispute between the applicant and the water sewer district, which is not our fight.
And
but this is the place where it might connect.
and I think that it's, in this instance, it's to a point where there is public service available to this property and to the use, such that it's not going to cause any sort of financial burden on the county.
Yeah, I guess one might dig into availability. If it's physically available, the pipe runs right by there, but whether it's legally available. All right, but your opinion reading this language would be that even in my extreme, if for some reason everything collapsed between them and the district and there were no public services available, that would not compromise our approval of the conditional use.
Well, that's,
Because we shouldn't
that's
be in a
not what we
position
were,
of counting on them working out their dispute.
well, but we also have there's no information to support that it's an impossibility. I mean, it's currently being provided from my understanding.
Okay, I mean,
So may I,
yes, please, I jumped on your question, so go for it.
in my view, and it may not be the right view, but in my view is, if there is an entity that has to provide services, and that entity says they have not met our requirements, and until they do, we don't want to give them our service, then we can't come in and say, oh, we don't care about you, in your opinion. I'm exactly with you on that the fact that there is a water line that goes in there doesn't mean that someone is willing to open a faucet. And so my inclination would be, I would like to take a step back, let the applicants and the water district resolve their issue before I make my decision. That would be my, because I think if there is a conflict between a local government and entity and a larger government entity, I think the local has to have precedent. That's my opinion.
But would you find a home for that in our findings? I mean, we have to confine ourselves to the four corners of our charge. And so would you say we cannot find the adequate public services are available? Is that where you would ground
In a
your
legal,
objection?
yeah, that will be my
Okay.
legal. And I'm not saying that we need to oppose this. I'm just saying that we need to have the local issue resolved before we make our decision.
But the basis for that would be,
Yeah,
has to be found in our findings. Okay, are there other thoughts?
that was my only one. We asked all of my other questions already. Thank you.
Okay, so now I'm looking at this.
Michael may have some.
Okay, oh yeah, Mr. Platt, let's exhaust that.
Can you hear me now?
Yeah.
All
Can you
right.
hear me?
Yes, my concern with this is in fact approving or recommending approval of a conditional use on an after the fact basis. And where does that leave us going forward? When the next time someone does something without permission and then comes seeking our permission or the county commissioner's permission, and we want to turn that down. It seems problematic to me, and it seems to me it would be subject to attack on an arbitrary and capricious basis, perhaps, when we've approved one and declined another. And I just wonder, how have you thought about that, David?
Yeah, so, Mr. Chair.
Go ahead, please.
Yeah, I get where you're coming from. I think, in our position, planning office position, we would like to ensure that all properties are complying with our regulations, right? And there's different ways to do that. And unfortunately, this is one of the ways. And this is an option. And it's really up to your recommendation and what the Board of County Commissioners ultimately decide on how that goes. But we provide options to the applicant or to a property owner saying, this is an option, this is an option, this is an option. After they've done something that they didn't get the proper permitting from, for whatever reason. And so this is the option that we're using. So it's up to you what you do with this application. I understand that it sets a precedent, but it's not a precedent that's set today or will be if this approves. So.
Were you provided a reason or an excuse from the applicants as to why this happened?
I believe they weren't aware of the permitting processes. I think that in their application where they discussed where they thought they were had a non-conforming use situation that they didn't need to. So it was just a lack of communication between them and the county from what they had said. So.
And it's your judgment then that this should be viewed favorably, that this was essentially an innocent mistake.
Not necessarily, but this is an option, and my job is to bring forward an application that's applied for and the fees are paid for, and that's why it's here. So, to me, I guess there's no reason for me to say that this is not a good idea, that I would recommend denial just based on whatever reasons they did this. The project itself, that's what I looked at. That's what I made my recommendation on. And that's what I'm bringing forward. And I leave my personal opinions, I guess, outside of the application. So
Matt, do you have any legal thoughts?
Certainly.
Let me jump in here before, if I may, because I do. And again, I'm looking for a home in the findings. Maybe and Mr. Ayers can correct me if I'm wrong, and I do not see a finding that the applicant has been in compliance in the past. So I guess I see this somewhat like the Water and Sewer District dispute of we are not in the business of enforcing our regulations. That's up to the county attorney's office and Mr. Kirch. We are presented with, is this a legitimate conditional use? So my inclinations from a legal point of view, just jurisdictional point of view, align with Mr. Gertch's that says, because you've abused the system mercilessly for 100 years is not a reason to deny a permit, unless we put that in our list of conditions. Okay, Mr. Ayers, you gave you a little time to think about this.
Yeah. Well, I mean, I think to a large extent, Commissioner Platt, it's a matter of policy preference. I mean, what sort of governance do you want to have? I mean, what are the punitive aspects of a zoning violation are fines. If it is particularly egregious, you may be able to, the county / my office may be able to get a court order to actually tear down offending structures. But I can say based on Wyoming on the very limited case law I've seen in Wyoming, it's incredibly hard to get. Even when it is a blatant and knowing violation, courts are hesitant to order that a structure is torn down, or at least in Teton County. But this, it's a resolution. My office has always advised the planning office that we are looking for resolutions. We are not looking for fines. And this offers a resolution for it to become legally compliant. So,
but to my point, I mean, could we, if we totally had our backs up, and I don't mean to abuse this applicant or doing this in hypothetical now, but had there been some long and continuing history of non-compliance, is that an adequate reason to deny a coming through the door permit application?
it is actually under
which?
In Chapter 1, Section 11, Enforcement and Penalty, C, properties in violation of this resolution shall not be issued a land use permit until the violation has been resolved to the satisfaction of the county. But at a certain point, to what extent, if the structure can be, lawfully permitted in compliance with the zoning resolution, you would have them tear it down so that they can reapply and do the exact same thing. We've always taken the stance that that is resolution satisfactory.
Okay, but if the county attorney felt differently, they could apply for fines or whatever it happened to be. Again, that wouldn't be anything we would do. That would be something that would be an enforcement.
Well, and ultimately and it's the board's
And
decision.
the board, okay.
Since the county attorney's office is not the plaintiff, it's the board of county commissioners.
Okay. But enforcement things don't come to planning and zoning.
No, they do not.
Okay, well, that's useful, and actually there is a provision earlier in the chapters that, thank you for pointing that out. Just my inclination would be to just treat it like it came in the door the first time. Now, something like the school district, I felt we got a little steamrolled with that because we would not have approved it as it came. So we would have put some conditions in terms of setbacks from creeks and so forth. So I guess my inclination on this one is to treat it straight up like it had not been built yet, and is it a acceptable and conditional use, and not burden it with past history or extraneous disputes. Again, that just would be my 2 bits worth. The other thing that caught my attention in the objections were all the boundary things. Now, are we in bounds to approve a conditional use? Does it have the required setbacks if we were just starting from scratch from property lines and all of the things that pertain to where you put the house?
So this area is in a neighborhood conservation overlay zone, meaning that there's 0 setbacks. And the survey that was provided shows that this building is within the property boundaries, so it should be good there.
So we aren't setting ourselves up for some dispute down the road where somebody's built in an easement.
Correct.
Okay, because that was a lot of the.
Yeah, there was some accusations that things weren't built within the property lines, but with the vacation, everything's within the property boundaries.
And the maps that you provided are amusing in that regard. The lines don't line up with the streets and everything, but.
Yeah,
But
don't go on the county maps and try to figure out where properties are in Centennial or Wold or
Right.
some of these other smaller communities that are on the hills. So.
Okay, but that goes to my other question. You're satisfied that if we put the proper lines down there within them and there are no setback issues?
Yes.
Okay. So then to summarize what I think I've heard is that there are no elements of the Water and Sewer District's objections, say from the August letter, that pertain to our approval of this conditional use application. Is that correct?
Correct.
Okay, so that's up to those guys. All right, I think that's all I had. And then I read those 2 letters the same as you, that the second one kind of took back the first one.
Right.
In terms of them pulling in their hearts and saying, we have a dispute, but it's ours and not yours.
Mhm.
Okay, so if we were to approve this, we would not be inconsistent with the recommendation from the Water and Sewer District because they didn't give us one. All right, thank you. All right, anything else we want to take up with our staff?
Mr. Chair, I have another question. Can you give examples of other commercially zoned properties that do have conditional uses for residences on the property?
I'm trying to think. Yeah, there's
We did that a couple
property
years ago.
down south of town on Gravant, which is off of Soldier,
Yeah.
it was off Soldier Street. No.
The
other one's the-
Fort Sanders.
Fort Sanders, off of Fort Sanders. So that was a situation where, yeah, they built, or they wanted, to
I think they
put
wanted 2
residences or like a duplex or something on it.
Yeah. What about the Golden Prairie Bakery? That was the same thing.
Well, that's a
That's not
in-home
commercial.
business. That's a,
That wasn't commercial?
well, it's a
Consider home
residential with
business.
a.
Well, it's a home business.
Ag zone.
Oh, yeah, egg.
I had one, I was looking through my notes, again, just a kind of a question on the exterior, the staff response on one of the findings, number 10, was exterior lighting should be screened. I always bridle at the word should in these kinds of things. Is it required or is it not?
That's a requirement, yes.
Okay, so then.
Shall be screened.
Okay, to clarify the staff report for the purposes of the board, let's say what it is. So if it means will be, then let's do so. Thank you. And I think that's all I had. And they could, oh, all right, one more just zoning question. Because they have water and sewer, they could be zoned urban residential. I mean, they could have split the lot and just done the residential part as urban residential. Is that right? Could they have subdivided this lot?
Wow, I don't know. It's already a small lot. I'm not sure if they.
Well, urban residential, just to remind my colleagues, we can go down to a quarter of an acre.
Right.
So you could have, I just wondered, could you peel off that quarter of an acre and call it an urban residential if you needed to?
Probably.
Just
That would have been an option.
an option. Yeah. All right. I was just trying to get my mind around the fact we don't have very many that come to us who have both water and sewer.
Right.
Okay. Other comments, questions?
Mr. Chair, to follow up on what you
Please.
just said, would that be a cleaner way to do this? To peel it off as a lot split with different zoning?
Not necessarily. I don't know. It would be more of a process for the applicant to do that. And the conditional use, if this use as a residence goes away for a period of time, then they can't do that anymore unless they come back before the board and Planning and Zoning Commission. So I don't know. This was probably the easiest. This is kind of the low hanging fruit of what they could have done. So that's why we went this.
Is that it? For the one? Mr. Platt?
Done.
Okay, could we get the applicant to, if you wanted to add anything to this, you're certainly welcome to, step up here and introduce yourself and.
I'm Dave Taylor, owner of Bear Bottom Bar and Grill, Centennial. And like Dave said, the way stuff is built there and it is unbelievable. Everybody that we've talked to, it's a nightmare for surveying and yeah, we messed up. The building on it was already built. It's a small, tiny 12 by 32. Didn't think my mess up. I didn't think I needed a permit it was already built. So, yeah. But we've done everything that Dave's asked us, the county's asked us. Done it all, what we can do.
And are you confident that you'll resolve your issues with the water and sewer district? Just to.
We hooked up water and sewer, but it's on our line, on our business line,
Okay.
which is a big water line and a big sewer line. It was all right there on our property.
And I'm sorry,
Well,
we did not realize we had a dispute with them.
yeah, okay, and so they're looking for
Nobody's
hookup
come and
fees.
ever
and-
talked to us.
Okay.
To David.
Okay, well, we've agreed it's outside of our jurisdiction, but certainly encourage
You
you.
were talking about splitting that property. I don't think there's no way to do that. It's so small. Like I said, the way it lays it at an angle, it gets very, very narrow on one side and then as it goes east, it starts opening up.
No, I remember many years ago, John Hill, you might remember, he was a surveyor around here.
Yeah, I've heard.
He
it.
showed me a secret map of the surveying in Centennial. He says, you can't take a picture of this or show it to anybody else because the lines are ching, ching, ching. 5 people might have bought the same piece of ground. So
Yeah.
I sympathize with that, but we'll try to start it out as best we can. Questions for the applicant here? All right, well, thank you.
Thank you, folks.
Again, sounds like you've got some other things to do, but not in this forum. Okay, let's convene our formal public hearing. I don't think we have anybody else here and nobody I see on Zoom, but just to be correct about it, anybody else want to comment on this? Hearing, seeing none, I'll take a motion to close the public hearing.
I move to close the public hearing.
Is there a second?
Do you want a second, Michael?
I'll second.
All right, we have a motion and a second. Discussion. All in favor, say aye.
Aye.
Opposed, same sign. Okay, close the public hearing. Now, what do I want to do with it? Anybody want to make a motion on that, or is there further discussion to be had? And I extend that invitation to both legal and planning staff. You guys, okay? What's your pleasure?
Well, Mr. Chair, I have to say, I agree with Commissioner Ben David about the idea of tabling it to wait for the water and sewer to get resolved, and not because of the economic harm finding, but more that the water, where is it now? Oh, am I even in the right? The finding that has to be made about, let's see, it's big B, little d.
Adequate water is right there at the start of the findings. Third one.
Number 4, water quality. The proposed
Oh.
conditional use will mitigate any adverse water quality impacts. Well, for one thing, if they are told by the district that they have to disconnect, then what would they be doing for their wastewater disposal? We wouldn't know. But also, I'm suspecting the reason why the district has rules about not continuing a water line is whether or not that poses problems with, like, if you don't have the right kind of redundancy in the system to prevent backflow into the system, or like, they must have a reason for requiring different lines. And is that reason based on a health-based concern? I don't know, but I guess I would feel better for all the things that aren't like being done to the letter with this application. I'd feel better knowing that the water and sewer was a resolved issue, and that we're not unwittingly allowing the creation of an unsafe water quality issue by the way it's currently plumbed.
So you're, again, to find a home for that, the suggestion would be we table the application pending resolution of water and sewer issues, finding a home in the water quality.
Or we can approve with condition.
Yeah. That's- why can't we approve? I thought we
Okay.
could assign conditions.
Mr. Harrison.
That was my recommendation.
I'm sorry, Commissioner Hanning, but that is there's a tenuous link to water quality. There's no, evidence that's speculative, and we have no authority whatsoever over centralized water systems as the county.
If they wanted to do a condition, could they tie it to 5C?
What's 5C?
That's the adequate public services are available.
So I don't think so, because I think Commissioner Ben David, your interpretation would be fine if it ended at, you have it up, Jeff? If that sentence ended with that the proposed conditional, or that adequate public services are available for the proposed conditional use. But it has the
The financial burden.
The financial burden clause directly tied to it. It's not and would not financially burden. The availability of adequate sewer and water is tied directly to whether or not it will create a financial burden. It's limited to whether it will burden the county, not whether it is just available.
So let me see if I understand everything correctly. We can deny the application based on that, but we can't approve it with condition based on that?
No, I'm saying that the way that condition is written, because of the without, that narrows the scope of the availability.
So basically, we have no course of action. And our whole discussion was a waste of everybody's time because we can only approve it. That's what you're telling us.
I'm not saying it was a waste of time whatsoever.
No, I'm sure you're not, but I'm saying, I mean, why do we as a commission need to discuss any application if the only options available to us is approve? I mean, what's the point? Why are we even discussing applications? What's the legal reason to discuss any application? Now we're departing from this specific one. If we have no options.
Well, my answer would be that we have to agree that these findings can be made. Those are not givens. If for any reason we think that we cannot find that it is leapfrog or this or that or adequately protective of screening and buffering, read the whole list. That's being brought to us. Those are subjective decisions. We have to affirmatively find that it meets those criteria. We don't have to take these gentlemen's recommendation. So no, I think there's a legitimate role for us here.
I don't see it.
Well, if you were to object to something in these findings, that would be our basis.
But Mr. Ayers is telling me that my objection has no merit.
In that particular, he has no basis in that particular
But that's
finding.
my objection.
Well, then your objection is not sufficient to justify denial, is what we're being told. I'm sorry, Mr. Ayers, I'm jumping in.
No, that's
But that basically is the idea.
My point is, again, why has this application brought to us for discussion? Given the application, given the findings, given the comments from various stakeholders, if we have absolutely no choice in the matter, why bring it to us? Approve it in the office. Take it straight to the Board of Commissioners. Why us?
Because David cannot circumvent regulation. It
What?
says it goes to planning and zoning first.
I understand,
So
but
here we are.
you don't give us any options.
I'm not doing this
No,
to
no,
you.
I don't.
No.
Do you understand that?
Let's be clear here now. The point is that the rules require us, the county, to make certain affirmative findings, and there's a long list of them. And we are being asked if we can sustain the staff's findings. Now, this particular one of about 15 findings, our legal staff is telling us that one is not challengeable under the criteria that we're thinking of, adequate water and sewer. He's saying that his advice to us is that you can't deny them to that finding. There's all the other findings. Do you feel that the water quality is not, they will mitigate any adverse water quality impacts? That would be a reason to deny it. That's in our findings. So no, I guess I'm pushing back against the notion that we have no role in this. We have a very substantial role.
My point is, when applications like this come through the planning office, where it is clear that there is no point in the finding where we can have an opinion that will carry legally, why bring it to us? You send it to us and you say, you guys already have to approve it because there is nothing else. We will just say aye and close the meeting after 2 minutes. Why are we discussing applications like this when it is absolutely clear But we cannot challenge any of the findings.
Are all of the other ones clear to you? I mean,
Yes,
clear to
they're
those
all
guys?
clear to me. The
Well, all
only
right,
one
your opinion has been solicited. This is being brought to us and we're being asked, is it clear to us that it satisfies air quality, water quality, wildlife impacts, all the things that we've put together? We're being asked, is it clear to us that it satisfies those? Is your answer yes? Then we approve it based on our answer of yes.
However,
We don't delegate that to these guys.
however, I do have an issue, but you're telling me that this issue is not meritorious.
That particular issue
Yeah.
is outside the bounds of our authority, I think is what I'm hearing. And that is out of our hands. And that issue is not being brought to us. Nobody's asking us if we think we should punish them for past misdeeds, for example. That's not in our purview.
And that's not the issue I have a problem with.
Well, one of the things that I would say is like,
Want to say that?
we're following the rules, right? Like that's why it's coming to you. But I may look at these things and think all of these everything's addressed. This is my recommendation. And I bring it to you guys and maybe somebody in the public comes and says, well, what about this? Well, maybe that's not something that was brought to my attention or I thought about. And then it's like, oh yeah, well, that's an issue. Now you guys can take that information that I didn't have and you can use that to condition this or inform your discussion. So, I think this is a good process. I understand where you're coming from, Ralph. Like it's, like, why am I bringing check? Why do I have to see it? It's all checked off, like I get that, but, yeah. I don't know.
Ms. Allen, please.
Mr. Chair, well, I guess, one of the things that's going on behind the scenes before it comes to us is the planning staff are doing a really great job of going back and forth with an applicant to get it into the shape where it is approvable. So that's why we are often like at wit's end thinking, how could we ever defy the planning staff? Because they do a good job of bringing us a carefully reasoned response.
It's a good way to think, Marav.
I was
We're
gonna,
good with that.
that's what I was gonna say. I mean, not necessarily the good job part, but we've been working with the applicant for months on months to get you a presentable application so that hopefully you do only have one option and it's our recommendation. I mean, that's why we're here. I mean, you don't see the original application necessarily. You might have in this case, I don't know. But just because you see the final application and it looks like you have one option, doesn't mean it started with one option.
Let's.
Never mind. I've said what I have.
Okay, I'll be just looking at the list of findings and trying to find a home for this. I mean, your concern is legitimate. Can we find that the proposed conditional use will mitigate any adverse water quality impacts? Is that where this lands? That we're saying, no, we're not sure what it's going to do with their wastewater? Ms. Hanning?
Mr. Chair, thank you. I guess, okay, so how do I organize my thoughts? You have to make the same findings for tabling that you would have to make for recommending or denying.
No, well, according to the regulations, or the zoning resolution, there's no explicit basis for tabling. But my advice would be that it has to be tied to a central decision-making criteria. So therefore, it should be tied to a finding.
And so the other branch in the road is conditioning the conditional use permit.
And that has to be directly tied to a finding necessary for approval.
And honestly, I would recommend that route.
Right.
Your recommending board, you can put that condition in there and then the board can make the decision if they want to stop things and table it at their where they're at to get something taken care of. But you can condition this application. I mean, finding a place for that specific condition is hard because, I don't know, the findings aren't not matching up with the issue. But that being said,
Which happens.
we're giving you recommendations and you guys can do with that what you want.
Well, so something I brought up earlier about the findings necessary for approval being that the proposed conditional use shall not harm the public health, safety, or welfare of the community. And I think it does harm the community to be supporting things getting done improperly, not only with the county, but with the water and sewer district. In that, I think to feel like you didn't have to be upset about 5B, like, yeah, I can let the county piece go by because that is the guiding philosophy of the county planning and zoning. But supporting not seeing the harm to the water district remedy, to me, would support either tabling until it's fixed or conditioning. Is that a reasonable way to?
That's exactly what Michael's point was.
Okay, good discussion. I'm moving. Does somebody want to make a motion? Is there something else you guys want to add to this?
Mr. Chairman, I'll make a motion.
Please.
I move to recommend the Board of County Commissioners approve the Taylor Conditional Use Application CU-01-24, adopting and incorporating the staff analysis, findings of fact, and conclusions of law as each are stated in the staff report, conditioned that the applicant satisfactorily resolves this dispute with the Centennial, I'm going to say Water District. That might be the Water and Sanitary District. And that's my motion.
Thank you. Is there a second?
I second.
It's been moved and seconded. Further discussion? Any objections? Comments from staff? Hearing, seeing none. Ms. Anning?
Aye.
How about you? Mr. Plath?
Aye.
Mr. David?
Aye.
Hinckley votes aye. I'm comfortable with that resolution. And that will then move forward as our recommendation to board, correct?
Yes.
Okay, thank you, gentlemen. Thank you, guys.
I have a question.
Sure.
Since we have got nothing from the water board, can we have the letter that was sent to you guys?
It should be in your email, but I've got it printed up so you can have.
Okay, thank you.
So the substance of the motion we just passed was resolved, I guess, and we would leave that up to staff to determine what resolved means. I mean, there's going to be some judgments in there. So is that fair to the understanding of what we just did? Thank you. All right, the Arthur Fork is not being brought forward. Oh, and you're no reason for you to stay. Thank you for your participation and thanks for trying to bring this all sorted out. Centennial is a perpetual problem.
Yeah.
Okay, so, but
Thank you.
it's just out of respect for those of us who spent some time looking at the Arthur Fork subdivision. If there are questions that we can learn from staff from, I think it's appropriate that we proceed to air those out. So I'll open it to my colleagues. Ms. Hanning, you want to start?
I went first last time and took all the questions from everybody.
Because you do such a great job. Mr. Platt, you're being invited to weigh in. If you had it.
I didn't have any questions.
Okay. I always have a few, but go ahead.
I had a hard time following the correspondence back and forth, so if somebody can simplify this about the road access and the engineer, Joe, maybe?
I guess, do you have a specific question or you just couldn't follow it?
It was how to follow where we stand and what was the concerns and how they were addressed and
Let me find those comments real quick. Oh, geez. All right. Maybe I should pull up my notes. So I believe on like one of the first plats they gave us, there wasn't necessarily a road displayed on, like, it was basically just their driveway that they have now. And that's what they had planned to use for the subdivision. And we were saying that it needs to be an actual road, but there was some trickiness with everyone involved because there's a small chunk of road that wasn't owned by them, basically. And so they had to get an easement to use that, like an official easement, not just a handshake thing. And so that took a while and they figured it out. I don't know if that it answers your questions or not, but
Yeah, I couldn't tell what, because there was, I didn't hear back. I did
yeah,
hear
there were
back.
questions and my comments don't go in these. They never have. So there was a lot of discussion between me and Jake, who was doing the engineering for this project for them, between what they need and what we would accept. So there was stuff behind the scenes, I guess, that you didn't see.
So they got the easement, proper easement,
Yep,
and they got the proper road.
yep. And then we didn't require financial assurance because they had taken care of what they needed to before, but like before the subdivision were to go forward.
It was impossible to follow.
Mr. Chair, I have a few questions. Some of them are just trying to understand the process. I thought we got rid of or I thought we changed the regs so that you couldn't do a preliminary and final plat at the same time. Is that
For
just
more
for
than-
larger
Yeah,
subdivisions?
for more than 3 lots, you can't.
Okay. So what would have been the potential future options a landowner would have had, had they done this split? Then there would have been a 5-acre lot with the house already on it, then there would have been the 18.47 acres that was gonna be a single lot. But could an applicant down the road ask to well, it's rural residential, right? Is that the land?
It was when they turned it in, but now it's ranch.
What was it before?
Rural residential. It was rural residential, but now it's ranch.
We
Oh,
just
yeah,
basically
right,
just
right.
renamed
I'm
it.
sorry.
Basically
yeah,
the same.
the old terminology. So they would have been able to further subdivide that, or once the final plat says it's gonna be one big lot, that's where you land?
So if they could meet the zoning, they could come back and subdivide that bigger lot, but they'd have to go through a major subdivision process. No matter how many lots they want to put it in.
Okay, so it would come back through for another bite at the apple, kind of.
And they'd have to do the major subdivision. So it'd have to be separate preliminary and final plat. It'd have to do all the DEQ studies,
Okay.
all that kind of stuff, all the water studies, all
And
the.
does the same go then for making a petition to rezone it, like urban residential because of all the small lots in Centennial. Like I could see somebody coming in and making the argument like, well, look at all of this. I'm just trying to do the same thing here. Right?
Is that bad?
Is that bad? If they're on the sewer district, I wouldn't think of it as bad.
Yeah.
I'm just trying to understand, like, when somebody.
I mean, they would have to go through the full process. It's not like we would just hand them
Right,
a
right,
zoning
yeah.
change.
No,
Yeah.
they'd have to.
And they'd have to go through the major subdivision again, no matter what.
Okay, what happens with this kind of landlocked parcel like this? They were talking about trying to buy it from whoever owned that 1.96 little acre.
So they actually own that parcel.
Oh, they already bought it then.
The property owners, yeah.
Okay,
It's like maybe a slightly different LLC or something like that. But it's the same ownership group. I think they were planning on basically dissolving the deed into one. I don't know.
and I guess my last question. Is there anything in the regs that would require you to hook into the district sewer if it's within some distance of? No.
It's not within
Not right now.
Not within a distance, but if you go urban residential, you have to be, right?
Yeah,
essentially
you have to
to have that.
Centralize something.
And if
Yeah.
you are within the established water and sewer district, then you have to play ball with the district. When they formed those districts, there was quite a bit of contention of voting your neighbor in, whether they liked it or not. So yeah, they have a footprint that gives them the taxing.
Yeah, like the weird part about this one is like you mentioned the landlocked parcel, like that's not in the Centennial Water Sewer District, but the bigger one is the one that surrounds it.
Yeah, that's interesting. Okay, thanks for entertaining my questions.
Okay, let me follow up just briefly. What you were saying, Mr. Williams. So you can't continue to slice things off as minor subdivisions. They kind of carry their.
You get one subdivision as a minor subdivision. That's why we tell people just to go, if you plan on making a lot of lots, you may as well just do it now. Because you're gonna have to do it anyways at some point, because I mean, they could do this 18 whatever parcel, but even if they wanted to do 2 and 2 and 2 or whatever, they'd have to go through a major subdivision every time.
Because they would now carry all those previous ones forward with them, and it would trip the trigger on 3 lots, or that's the logic.
Well, I don't know. We just have, it's part of our regulations that any previous subdivisions have to go through a major subdivision.
Any subdivision that is within a previously platted subdivision is cannot use the minor subdivision.
Yeah, there's a list of things that if they hit, they can't do the subdivision. That's one.
No, thank you. It isn't a count, it's just a sequence. You can't sequence.
Yeah.
Mr. Platt, do you have anything?
I don't have anything.
I have one question,
Yeah,
but I don't know if it's.
just open
There's a
discussion.
map.
Go ahead.
There's a map that says approximate property boundary, and the actual barn, I guess it is outside of it.
Do you know where?
Let me see what
What
page
page?
it is. Hang on.
Yeah, because I
Right.
mean, the story of this application is I published the agenda, and then about half an hour later, I had a phone call saying we were pulling our application. I was like, okay.
Yeah, I mean, I looked at the map and I said,
Do you have a page number?
yeah, it says page 9 on something soils. Oh, wait, in the whole document, it's page, hang on. 76.
In the PDF you're talking.
Yeah, I mean,
So I think
So
this was like before it was surveyed, they were doing the soil data.
and With the soil data, I mean, I think you're always gonna be looking at a little broader scope than just the property boundaries. So
Yeah.
it's kind of, you don't need it exact necessarily.
Yeah, I wasn't sure, it just seemed odd. But I understand
Yeah,
that. the
I'm
line may not-
assuming this is from, I don't know what.
There's a
what
website.
site he used, but there's like a soil data
Soil
site,
web.
and it's kind of got like our ownership layer. It's not like an actual survey, that kind of thing.
Okay.
Yep.
Looking at the staff report, it talked about a variance. Now, again, I know it's not in front of us now, but then I didn't see that show up again in your recommendation. Where did the variance fit in?
For the cul-de-sac,
Yeah, you'd said that if the planning and zoning approves of a variance to the standard, this is on just right there in your initial bullet points. Tom.
yeah, I just said a recommendation of approval of this application is acceptance of this variance.
So
So if
that
you
would
wanted to not accept it, you could have just pulled it out.
okay, but if we were to move forward with this, we would have been approving both the subdivision and that variance. That was the sense of that. Okay.
Maybe David and Joe, could you explain kind of that weirdness with that variance in the cul-de-sac?
Yeah, this is an annoying one that comes up pretty much every subdivision. It's just in our standards that a cul-de-sac can't be 600 feet or longer unless you guys approve it.
Yeah, I think there's a couple standards. I think if it's over if the lots are gonna be over an acre in size and the planning and zoning commission is okay with it, then it can be approved. But it's specifically in that little paragraph. It's not like this is a variance, like we have the variance process or the variance, section. This is a variance specific to that requirement.
It's more of a, permission, I suppose would be the.
Yeah, maybe the
Better
verbiage
word?
is just weird to say variance, but
Okay.
But we've been working on.
it's been in there forever.
Chapter 6 to rectify that and a lot of other things.
Okay, well, that would have been my confusion. So I was looking for a variance.
No,
So-
yeah.
Yeah.
There's a long piece in findings necessary for approval about within a mile of the governing city or town, but there isn't, Centennial's not
It is
a
unincorporated.
town. Okay, so why is this even in here? Is this relevant? Maybe I didn't read it.
What page is this?
It's right, it's on page 3, findings necessary for approval. Starts right out, pursuant to chapter 2, talks about the 1 mile in the governing town, or was that?
Yeah, I mean, it's just, this is in I see what you mean. That shouldn't be in there. The staff comment shouldn't be in there. The regulation, we have, been asked by the attorney's office to include all of these and kind of like mark off like this has been done, that kind of stuff. But the actual staff comment, that shouldn't be. That's an incorrect staff comment.
Okay, so that's my guess is that was just a holdover number, because that really, it doesn't apply to this at all.
It doesn't.
Okay, that just want to be clear what I was seeing. Then there was a spot where, where are my staff comments at the end of item 4, and it talks about putting on the plat. Water service may be provided by Centennial Water and Sewer District and is subject to their determination at a time of application. Otherwise, an on-site bill will be provided. It struck me as odd that that would be on the plat. And what does that mean to have on the plat, on-site well will be provided? Is that a requirement that we're saying, and who enforces that, or what does that mean to put that on the plat?
That's what they put on the plat.
Okay.
It's saying basically we're gonna try and get water service, which they already are in the district, so it shouldn't have been too hard to get it. But basically, if the water district says no, then they'll go with a well.
And I guess just legally, then, is the seller obligating him or herself to drill this well? But what does this mean, will be provided by who?
I don't know. That is not, that language is not something that we
Yeah, it's weird.
require in our because we require a lot of language to be on the face
Oh,
of the
yeah.
plat, but that is not one.
This would have been a Jake question.
Yeah, we have a lot of like, most of it's like, you know, no public maintenance of roads, no public, and a lot of it comes specifically from statute.
Yeah.
You know, just because you build a house doesn't mean you can't drill for minerals under your, I think that's something we have to put on it too. There's something about mineral rights, but like,
Oh, yeah.
but yeah, it's not us.
What do we require them to disclose on a plat that there is no groundwater, for example? If we were to do the study, and they have to disclose that, but that's again a protection, which isn't this. Okay, well, maybe that's something you guys could ask Jake about. It struck me as an odd thing to see on a plat. And made me wonder, well, who's talking there?
It would be a fun legal question that wouldn't involve the county at that point.
It
Yeah,
would be between
It would not
whoever
be us.
sold it to them.
Yeah. Whether that like somehow conveys as a warranty or.
Yeah,
Because what's required to be on there is that there's not gonna be any public water supplied or whatever, but this is kind of a public water supply.
yeah,
so
that's
it's like,
why they're
well,
saying
maybe
this.
it's
That's-
on there, but
that's
maybe
why
it's
they're
not.
saying
So
this.
I guess,
somebody promises that if you don't get hooked up, we'll drill you well. All right, those were the questions I had. Other thoughts that came to mind as you were looking through our.
Just, Mr. Chair, a quick question that came to mind when you said that would have been something to ask Jake. What is the procedure for selecting the county engineer? Because I was surprised to see that. And I thought Mr. Gorman had retired and Jake was. But
Yeah, so
rotating.
Bill
or,
retired, but said that we could use him if, this situation comes up or whatever, so.
So Jake is still the county
Yes.
engineer, but he had to recuse himself from this one to be the applicant.
Yeah, because he can't be the applicant engineer and the county
Right.
engineer at the same time, so.
Okay, thanks for explaining.
yeah, and since Bill knows our regulations, there used to be another engineer we would use occasionally, when like if Bill was working on something, but I think he's kind of retired, so more retired than Bill.
Okay, Mr. Platt, you satisfied with this one?
I'm fine.
Okay, all right, let's move on then to a more interesting piece and relevant. We're going to talk about the Laramie Growth Area Intergovernmental Agreement. Now, I understand this is simply for our discussion, but perhaps we can improve it by our questions and so forth. So start us off.
Okay, so after months of work with the city of Laramie, we are presenting to you the draft intergovernmental agreement for Laramie Growth Area Plan. We're happy to take your comments on this. I'll just kind of run through what the pieces are. The big pieces, not all the legal pieces at the end that I don't care about, but Matt does. Just joking.
Contract.
It is, right. So, but basically the meat of it is there's a few things that it kind of addresses. The agreement allows use of the growth plan as guidance for zoning and subdivision decisions. It defines the growth area. So as part of the growth area will be included. I don't think I included that what I sent you, what I remember. And then it provides communication standards between the county and the city. So what that is it's specific, and that's just a general statement, but if somebody comes in and is going to do a zoning change within the growth area, then we would provide notice and information to the city. If the city receives an annexation request from somebody, that's within the growth area, then they would provide us notice of what's going on. It's just kind of communication. We just outline that. Also, it outlines regulatory changes that Albany County and the city of Laramie will make. And these include right-of-way dedication. So one of the things that the county would do is we would require all subdivisions within this area to dedicate as right-of-way where the roads are going to be or whatever, as opposed to just an easement. So we allow this right now, that if there's a subdivision, they can have an easement, meaning easements and right of ways are kind of the same thing, but they're kind of not. But when I talk about easement, I'm talking about here's 80 foot of easement, but your property line is actually at the center of that. Right of way is, here's 80 foot of right of way, and your property lines ends at the right of way. It doesn't go to the center,
Well, it's the right way.
the public.
Well,
Yeah.
yeah, no.
Well, it's dedicated to the public, so whatever that means.
It is, if it's within unincorporated county, the county commissioners, hold a fee simple determinable, interest, where it's essentially the surface estate is being held in public trust.
Okay,
So who owns it? Nebulous, sort of.
and that an easement functionally is
Nothing.
nothing.
That,
Okay,
yeah.
So you pay taxes all the way to the middle of the road if you have an easement. But if it's a right of way, you don't pay taxes on that portion. So don't look at it that way.
interesting.
Because nobody pays
Oh.
taxes on the right of way.
Oh, yeah. So.
Yeah. Anyway,
I didn't know that.
It's one of those, all squares are rectangles, but not all rectangles are squares.
So it's the advantage of the property owners to have it a right of way, because they can't do anything with it anyway, so why pay taxes on
But
it?
they don't own the
They-
land and they
Do have a fee interest. But it's a contingent, future interest.
like that property doesn't count towards like the subdivision. Like when you're doing a subdivision, it doesn't count towards the average.
like the lot size and the density, yeah. So the benefit for a subdivider is if they come in and they're like, wow, if I take this out, I'm losing a lot. But if I go to the center line and just do an easement, now I get an extra lot. So.
Okay. All right, that's
Which we allow in the county. I don't think it's that huge of a deal. It becomes more of a deal for like the city. So if the city is ever going to take over any of these roads that are in subdivisions that are in this growth area, they don't want to have to deal with the landowners that actually own the land.
Mhm.
They want to have access to that road to build or to maintain or do whatever they need to do to it.
so this is right of way, is what.
But if it's
Yes.
publicly dedicated, it becomes a right of way. At any point.
Even if it's the easement is to the middle of the road.
Because that's showing where the middle of the right of way is. That cannot be counted.
But they don't, but is what
The
I'm.
surface estate is severed, because once you
But they-
publicly dedicate it on a plat
Right,
to the public, that is always a publicly dedicated right.
but the property owner still owns to the middle of that road. They
They do
still
not.
own that.
They do not. They don't own the surface estate.
They pay taxes on it.
Yeah, well. But
So,
I'm telling you, like service estate ownership. I mean, I don't know that's, taxation and everything else is kind of a different thing.
well, so, okay, let's step back because actually
Well, I
what
don't
we
know if-
require on our subdivision is the right to dedicate to the public said easement. So maybe it's not actually dedicated at the time of subdivision, not till the county accepts it, and then it would become.
No, that's dedication of a county road.
I don't know. Moving right along. We can have these over lunch.
Roads and water are the things we fight about in Wyoming.
Right. So that's the right of way dedication. So everything would be taken out of the lot, basically. That's what we would give here. Improvements within the right of way, basically it's saying that we're going to require regulations for improvements within the right of way that have to meet basically the standards that the city has, if they meet certain criteria. But these things that we're talking about are like what we will look at when we go to the regulation stage. Municipal services, it also, we will require, if the property is adjacent, to the city, we will require water and sewer to be connected. That's basically what this is saying. This is something we would put into our regulations as well. The city will also allow the extension of water and sewer to properties that are not eligible for annexation. That's That's the city's give. They're saying that
Big one we were looking for.
if a property is not going to be required to have water and sewer, but they're outside of that area and they would like water and sewer, the city will work with them to get water and sewer, so long as they can provide that and they don't have any problems or whatever. So, which I see your smile.
Sounds a little squishy,
So,
but all right.
It's a little squishy, but this is what we got. So, but yeah, so that in a nutshell, those are the big things. This is really just kind of the gateway to the regulation phase. In my opinion, there are some, I mean, I guess the situation where, or the part of the agreement where it says that we can use the growth plan as guidance for the zoning and subdivision decisions, that might be something that is a little different too, because then we could use the plan, right, Matt? If we put this in the agreement, that is approved by county and city?
For zoning district amendment?
And subdivision.
No, it can be subdivision.
I mean, we might have to change our subdivision regulations, but
The subdivision is always a development. So you can't just use the plan as the basis for decision making.
but
It
the
has-
plating statutes has that whole section saying
It
that
does.
there can be an agreement
Oh,
that allows.
yeah, but those plating
Right.
statutes also say that you shall,
Yes, I don't-
no, that, the plating statutes more or less got nullified by one.
Okay. Well, anyways, that's it. That's in the nutshell. So now we can discuss.
Yeah, let me just following on that, pick up the torch from my colleague, Ms. Van David. If we agree to this with the city, then we kind of do have to do certain things in our zoning, right? I mean, that's, this obligates, this contract, it obligates the county to then follow through.
Correct.
Okay.
Yes.
So there will, if that came to us, you would say, we already promised the city we would do this, and then we don't.
Yeah.
Like I said, kind of a similar thing to what we were talking about earlier.
Yeah.
I guess I just raised that concern that what does this obligate the county to in terms of its follow-up regulation?
Well, it basically says that we're going to include these
Yeah.
into our regulations.
So we're kind of writing regulations here, sort of.
We're you're obligating yourself to make regulations in a certain manner, yeah.
Right. Well,
Yeah.
that's, okay, it just sounds a lot like making regulations.
Right, well, but the regulations, so I mean, if, it's like one of those things where if an application like came in the day after this was signed, we'd be bound with a contract, but if we didn't have regulations in place, we couldn't enforce,
Okay, so we probably want our regulations in place before we sign this.
no, because part of it is implementation. The parties shall use the LGA's guidance for land use zoning, infrastructure, and zoning and subdivision making, and amend their regulations to be consistent with and implement the LGP. So it is speaking to the future.
Okay. All right, well, that struck me. There's some coordination maybe needs to be refined there. I had some other questions, but let you guys go.
So this agreement is beyond what the proposal for the growth area was, because it doesn't include roads. So it's already an improvement. But it's, again, only talking about water and sewer and roads. Are we satisfied with that? We have no room, no place to talk about other issues that may involve for expanding the city of Laramie, like recreational public spaces, Do we want to coordinate with the school district? We might need new schools. I mean, again, this seems to me very limited in scope. And lead us, we sign this agreement, and in 2 years, when we start, approving things, come up with problems. So now we don't have a place for a school in this new area. Developed city north, and now we don't have room for a school. What do we do about that? I mean, again, it brings me to my original objection to the whole growth area plan, that it is too limited in scope.
Yeah, so I mean, what you're seeing here is a reflection of what was recommended in the plan. And you're right, the plan doesn't address open space, schools, recreation, any of that. I think the idea is as the city grows into the county and follows, kind of the plan and what the vision is of this whole process, then the city will extend their parks and recs plan, and their requirements will also, trigger that. The county doesn't do parks and recs. That's not something that we're involved with, but the city does, and the city will apply those standards when they, when property's annexed and when developments happen that are part of the city.
Yes, but again, we are counting on the city to be proactive in these cases, and they may not be.
But am I correct? This is our agreement with the city and what we need them to play ball with. This will then flow into a growth area overlay.
Yeah.
Within which we can zone in any way that the county feels appropriate. I mean, some of what you're talking about, I think, finds its home in our zoning. It does not require agreement from the city. All this is just the pieces that we need their agreement on, by understanding that, right?
Yes.
I mean, I'm not saying we're going to, but then our overlay could zone recreational or schools or whatever we want it to. I don't think that's going to happen, but that's where that would live, is in our overlay zone.
Right. But I think am I wrong with it? Is this your point is like, as the city grows, so now it's the city, it's not the county. So regardless of what our zoning is, now it's in the city, and the city doesn't necessarily have to do that because it's not here. That's what I'm taking from.
Exactly, you got it.
So you want to obligate the city to our vision of what that looks.
I think we need to work together to understand what the vision is. Beyond I understand I'm glad to see the roads in there, by the way. They weren't in the original, but I think the same reason for including the roads in this agreement, we should have a mutual vision that we work on, because we're gonna rewrite our regulations, right? And the way we rewrite them does not account for all the other things, and then the city will come back and say, hey, you didn't leave us anything. Look, you subdivided you turned everything into residential, and you didn't leave us any room for green space. My point, okay, I don't need to repeat myself.
Okay, so I think I don't think that we have the vision to say we, the county, want to have you not build a park there because the city might want to park there someday. That's kind of where that would go. Yeah.
If we work with the city together on a comprehensive plan, I think we'll be in better shape when we rewrite our regulations.
Legally, we could. Our comprehensive plan has to incorporate the city's comprehensive plan. So they get to write their own comprehensive plan. I think that would require an invitation from them, which
I don't see why we can't approach them and say, here are our concerns, can we work
but
together?
then we're getting into a comp plan rewrite. Really, I mean, the whole goal of the LGAP was to avoid a situation like what was happening to Cheyenne, where Cheyenne, where their city limits were boxed in by ranchette development, rural residential type development. and they didn't have anywhere to expand to. Pretty much the entire primer for this is how do you get someone in the county to go to municipal level development in terms of density and municipal services.
Just to give you an idea, we did have proposals that we reviewed where, according to the growth plan, the city wanted higher density, but the landowner, the property owner said, no, I want to have my own house here. And that was, if you look at it from a planning perspective, would have been much better to have it subdivided more. My point is that unless we really do work with the city very closely, we are going to make decisions that will box the city in unless we work with them. And part of the thing is that the city does have to work with the school district and does have to work with, recreation. So my point is, again, this is an improvement of the original plan that I've seen, but I don't think it's enough. I mean, what do they want? We need to know what they want, because if we are going to start approving things right and left with new regulations that don't match what they have in mind, what have we done?
Based on, I think, our experience with the city is that won't be an issue, knowing what they want. They seem to be pretty intelligent.
Yeah.
But yeah, I think a functional part of this, I mean, it's not envisioned in the plan, but what will likely happen is I am doubtful that there will be much extension of city water and sewer without annexation. Functionally. At which point, then you're in the city, all that applies to what the city wants, because it's their jurisdiction at that point.
Are we willing to commit the chair of the county commission to sign this based on what we believe, what we think? This is a legal.
I mean, that's up to the commissioners.
I know, and that's why I'm raising my concern.
Other thoughts, comments on this?
Mr. Chair, I have a long list of potential wording comments, but just to follow up on this sentiment, I did feel that some of the sort of philosophy espoused in the Laramie Growth Area Plan did not carry over into the IGA. Like some of the specific wording in the LGAP says that it will future residential, commercial, and industrial development, as well as how natural resources and open space can be protected. I mean, there was a lot more wording in the LGAP that gave, thought to natural resources and open space that didn't. The sentiments didn't carry over into like the whereases.
So I would challenge you to then trace that through the rest of the LGAP. My impression was it kind of fell off.
It fell off
within the plan itself.
Correct.
It talks about all these things, and then it gives you a map.
Correct.
And talks about extension of water and sewer.
Well, the map
And roads.
shows the boundary of the APOZ. I mean, it shows a protected natural resource area. We don't have anything that protects open space per se, or view shed. The City Unified Development Code does require for subdivisions to set aside either a certain amount of land or money in kind for park space. So like the city already has a way to incorporate park space as they grow in the Unified Development Code. But I just was surprised not to see some of that philosophy included in it, or even the idea in the whereases that one of the things this plan does is it provides predictability for property owners and developers. And like that idea wasn't like, if you want to sell this IGA, right now, it doesn't look like it benefits the common citizen. Which, like, both governmental entities are here to serve, right? I don't know. I looked up one of these that Gunnison has, and it included those same sentiments that I thought were presented in the LGAP. So if you're challenging me to go look further at where I can find little tentacles of those ideas showing up in the rest of the plan, then I'll go back and do that.
Well, perhaps, I mean, challenge is not the appropriate word. I
It's okay.
apologize for that, but it's just like, it's not, there isn't like a concrete plan there for that. I mean, that's a sentiment expressed up top, and then, you know.
Well, I guess, maybe I don't understand. There was the map, as a comprehensive plan would have, and it has commercial centers and, like you pointed out, the corridors. I guess I read this as having nothing to do with that map, particularly that map would guide our zoning within the overlay that we're talking about creating. And it can have whatever we want in it.
Well,
So
the whereases can have anything we want in it too.
Yeah, but where I
Why does the city need to agree up going into it what we think, where we think parks ought to go?
No, not where parks ought to go, just that it's a guiding philosophy on regulations that get developed.
Whose regulations? Ours?
Yeah, I guess it is ours.
it's,
So,
yeah.
then we're talking to ourselves. That's where I'm
And
lost.
theirs, when they annex something. Like, so I'm troubled by not having a carve out for protecting the aquifer protection overlay. That if the city were to start annexing parts of that and putting it on sewer, that's all good that you're collecting the wastewater, but you're still having an impact by having activity at the surface, right?
The growth area plan didn't go there.
No, but
That's why I voted.
The
But
cap does.
But I
Maybe.
thought the IGA was a place for an agreement to be made to say, in this contract, we, the city, agree that we're not going to annex any land in APOZ. Or if we do, it's gonna remain 35-acre lots, or we're gonna follow county zoning. I mean, like, they can agree in a contract to certain protections, right?
They can. I'm also. Every single time the composition of city council or the board of county commissioners changes, this becomes a voidable contract.
Right.
So, it's not that sticky.
So that leads me just to a question. Is it the county or the city manager who signs this, or is it the city council? Because right now it's worded to be the board of county commissioners and just the city. And I just wonder, does the city council?
Mayor and president of city council is the senator for the city.
On the bottom.
Okay,
Who signs
well,
it?
the wording in the parties doesn't specify, like the very first paragraph, number 1, parties, doesn't spell out city council there, but maybe it doesn't, maybe it's implied in the municipal corporation. And I guess another thing about this is the LGAP was written always with the county and then the city. And I guess I think this would be maybe viewed more palatably if it was worded to say the county and then the city everywhere. Maybe that's minor, but it is, all the work on this is coming to the county, so I guess I just thought we should get like first say in the order of power, even though it's joint I don't know. I'll let somebody else have a turn before I give you more like specific ideas of wording additions.
Yep, Mr. Platt, we haven't heard from you. You want to wade in here?
Well, sure. I concur with the basic thrust of Matt's comments. I think primarily this is a plan for a vision for growth. And that is primarily addressed by the map with how the land has been designated for different zoning, by and large, which will allow for different densities and types of development. I have confidence that the city, as it grows slowly, will be making allowances for parks and recreation, as have done in the past and continue to do today. I don't think that's the county's job. I'm absolutely confident the city has as much vested interest as anyone in preserving water quality with the Casper Aquifer, so that doesn't concern me at all. Of course, someone can make a bad decision. We can make a bad decision. And this is about what I expected the IGA to contain and address. So that's how I see this.
Yeah, thank you. Ms. Goodyear.
I just want everybody to try and imagine applicants coming in for requests for subdivisions, for rural residential and chats, whatever, within the growth area. And we tell them, no, you can't do this because this is part of the overlay. And the city would like to expand or annex or whatever. And they want to have, parks and recreation or schools or whatever, but we don't know what's the plan is. So we're not going to let you subdivide and develop because the city, we trust the city that when they annex you, they'll do the right thing. How can you do that? It just doesn't make sense to me that you can impose an overlay on a large area around the city without having at least a vague plan. And that map is, we'll talk about that map another time. I don't think so we're putting on ourselves a burden of how we're going to approve development around the city just by trusting the city. Meaning, no, we are not going to approve the subdivision because the Laramie growth area says it will be X, Y, the city wants it to be X, Y, and Z, when the city doesn't have a real plan. It just seems a wrong tact.
Okay.
To say to someone you can't subdivide because the city parks and recreation, we trust them to develop a nice park here, doesn't make any sense to me. If we are signing an agreement, if we are committing to this, what are we committing to?
Well, I guess
Mr. Chair.
yes, go ahead.
Commissioner Hanning, as the only person with experience on the city side, how much does city planning, look at schools? Since, that is the school district, which is a wholly separate entity, and it seems that they have some planning. I know I used to live on 15th and Thaxton, like very north end of 15th. And the city owns that entire lot on the other side of 15th. Yes, I would imagine in anticipation of future school going on. How much is the city involved in like that kind of school planning?
I never saw it come up in my time on the Planning and Zoning Commission because I thought that was like a school district responsibility and, acquiring lands and turning them into state lands. And, right now our school district is shrinking as opposed to growing. But I think there's mechanisms in place to deal with growth that are not I think, the city's decision or the county's decision, but that it's the state and the school district.
So I
And I
guess,
mean, you know, that is a zoning control that the county has never utilized, but you can have open space requirements. You can have clustered development where we give you permission to go lower in density if you leave X amount open to open space or some sort of like community purpose as part of your subdivision. You know,
but couldn't, I guess where I was picturing this, and I share your concerns about the map, but let's say we all did agree that the map was the ticket. Couldn't this county then say, okay, our growth plan guiding our zoning says this is going to be open space? And we would zone it accordingly. If somebody came forward and said, I would like to build a subdivision there, we would say, no, it's not compatible with the zoning. So there is a vision there that was in the growth plan, whether we'd like it or not. Let's just assume that we all agreed to it. And it just seemed like it was almost zoning on its face. It had commercial areas, and it had green areas, and it had the aquifer separated.
And you believe that this agreement takes that map, whether we like it or not, but there is a map. Do you feel that the way it's written reflects the map?
No, I don't think it needs to. I guess
Yeah,
my vision of it,
does.
well, we
Because
could do
it's-
whatever we wanted to within our overlay. We could, right? I mean, I don't care what the city says. The county could put a growth area overlay down, just like it
Yeah.
has for the aquifer or anything else, and say, based on the growth area plan that we, the county, adopted, we are going to zone this perpetual open space.
But
We
this,
don't need the city's permission to do that.
it obligates the county to amend its land use regulations to be consistent with and implement the LGAP.
Okay.
So, I mean, consistent with gives you a little bit of latitude, but it doesn't give you carte blanche to just.
But I could pull off the open space as identified on the maps that
Yeah.
they agreed to and zone that open space.
Correct.
Okay, that
Yeah.
doesn't need to be part of this agreement with the city. Right.
Oh, well, yeah, no, I mean, the county could go forward with the LGAP with or without
Right.
this agreement.
Right. So I guess my sense of the agreement, I just come at it from a totally different perspective. All that the county needs from the city is the city's commitment to bring water and sewer out to these areas that we're going to insist be high density. That's all we ask the city to do.
Right, because that's essential for the whole zoning scheme. You know, if we can't get that, then why are we zoning all this stuff for like high density development if it's not touching the city? There's no reason to.
And we did.
Other than to stop any type of.
It wasn't as I've expressed in the past, I thought the whole point of this was that we and the city agreed that we would like to see higher density development adjacent to the city. We can't require someone to do small acre lots. I mean, they could just I'll do half acre lots and sell them 10 at a time. The way that we guide that process is by requiring water and sewer, which is only economical if you do small lots. I mean, I guess that was my understanding, or this whole thing, that was the tool by which we were able to get small lot subdivisions.
And it's a necessary condition for small.
And then those go hand in hand. And so the only thing that the IGA needed to do was commit the city to backing us up. So that when somebody comes in and says, I want to build my 5 acre lots here, we say, fine, but you're going to have to provide water and sewer to all of them. Then they're going to say, well, all right, let's go with 1/4 acre lots. That's the objective. And otherwise, what happens in the growth area is a county zoning issue. And we don't need the city to agree to any of that. All we need them is to agree to bring out water and sewer if we demand it of our applicants.
And then we did build this in, so if that doesn't happen, it reverts back to base zoning.
Or overlay zoning or whatever the county.
No, well, this IGA says if
They don't want to get water.
Yeah, where the heck is that?
I mean, the map,
The county shall require connections. No, did we? Thought we had that a little more explicit in here, but I guess not. The county shall require connections to municipal water and sewer for subdivision that is contiguous with or adjacent unless the city determines not
right.
to pursue annexation. Yeah, and then
So isn't that the part that addresses the concern you expressed about, like Cheyenne, is that somebody comes to us and says, I want to put in my subdivision. We say, fine. You have to put in water and sewer, and the city has agreed to give it to you.
but the flip side of that is if for whatever reason the city determines not to, then we're not going to require it, and it would revert back to base counties.
And that was, my concern with this is that it left too much of that on the side of the city, that we were saying, boy, we're gonna put the squeeze to anybody that comes in. And then they're gonna say, nah, we don't care, because of whatever their criteria are that are undefined. My reaction to this was that it does not obligate the city sufficiently to do that.
Well,
Water sewer.
And I think that is that's a fair criticism.
yeah, well, and if they don't, then the developer comes in and says, well, I want to do a subdivision for county standards, and negates what the city want to do in the first place. So it'd be on them. So if we would allow it.
But
Because we have to have that relief valve. You can't just say,
Otherwise, it's a taking.
but higher likelihood than anything else.
Well, right, but this could say the city, okay, city, if you want small lots, you need to obligate through this agreement that you'll provide water and sewer. I mean, that's what I was expecting this to say.
okay, and if not,
Well, this is as good as we could get because we fought over what we have.
Well, then if not, then we are just county zoning. And if we don't like county zoning, then we can do whatever we want to with county zoning.
but the problem is then that we will have leapfrog development and we will have boxed in ranchettes around. I mean, what's the point of the growth area? The whole point of this agreement, of the whole planning, is to actually create a plan that can work.
Okay.
And so we're saying, oh, if the city doesn't do it, then we'll revert back to our own plan. That's exactly what we don't want to
Does
happen.
this obligate us to reverting back to our old plan? I mean, I'm picturing a aquifer, you left the aquifer overlay. Here's a growth area overlay within which we have defined land uses. Isn't that?
If you're not okay with the current zoning, we could change it.
Well, that was my thought, is where this was headed, was towards a growth area overlay that would be a county thing under county zoning authority, consistent with the county's approved Laramie area growth plan.
Which kicks in on subdivisions and zoning changes. But
Okay,
if you're not a fan of the base zoning, then change it.
well, that's where I thought we were headed with this. Now, does this obligate us to not do that? I would, if it does, then that's an objection to this agreement.
To create our own zoning scheme?
Yeah.
No.
Okay.
No, I mean, all this obligates us to, I mean, in that vein, we're just supposed to be using the growth area plan to create the zoning. That's all it says in here,
Okay, and
which is what we would intend to do in the first place. So the agreement is really just like, this is the direction we're going. It's not supposed to be specific regulations. You know, this is just a broad stroke. This is kind of where we're headed. We got a few things in here that like was mentioned, we got the water paragraph, whether it does what we want in there, that saying that the city will provide water. That's what we needed. And we put a few things in there the city wants, you know, the dedication of the public right of way, which is not even a big deal I mean, that's not a bad idea in the first place. And so it gives us a direction, gives us some opportunities and requirements to basically communicate with each other. But when it comes to the zoning and honestly the subdivision rules, when we look at those, that's us. That's us. You know, we've got a few things in here that they want us to include, which is part of the growth plan, and we're okay with that. But this is not supposed to be like the specific requirements for everything. You know, this is just supposed to be giving us direction.
This is where we're headed.
Well, but it's the teeth in this, as I read it, is the city obligates to bring water sewer up if we require it.
Yes.
Okay, I mean,
Yeah.
that's.
If they can.
Well, and then
It's
that's.
a little, it's a little
that's where
squishy.
But they have to
Yeah.
be able to tell you why they can't. There's
Yeah.
criteria.
I mean,
Well,
they-
they're not
that's the best we could get.
But that's
is like
what
that
we
they
can
would,
get.
they would justify it.
Yeah.
And so it talks about this criteria, and my flag was, well, what is that criteria? For annexation, when the criteria is satisfied. I mean, that's, again, my general comment on this was it leaves it completely on the side of the city. And we're supposed to be the heavy when people come into us asking for a subdivision.
I mean, the criteria is essentially like, can it meet the DEQ, like rules and regulations for a municipal, or the standards for like a municipal, public water supply.
Okay, that's codified someplace, what that criteria means.
It's just the whole chapter of the WDEQ regulations, which covers things that, when you look at that, like I was trying to like, okay, well, where, like, they don't point to a specific section of the chapter. It's just like the 73 pages of the
Right.
chapter. And when I just scanned through at the names of the sections, there was nothing that was like criteria for extending sewer. I mean, so I don't know what they meant there. It looks like it's a catch-all to say no.
Yeah.
But also I'm kind of confused because one of the maps in the LGAP is extension of sewer into like the Sherman Hills area. And that's not a subdivider that you're working with at this point. It's homeowners. And so right now, this 7.3.2 only talks about communicating to the subdivider in the county, but it's not broadening that out to individual homeowners already in a subdivision with demonstrated water quality problems. Like that's not in here anywhere. That one of the reasons why the city might consider extension without annexation is to address demonstrated water quality problems.
In the plan into Sherman Hills, it's talking about water, not sewer, unfortunately.
No, the map shows sewer running out there. For some reason, every time I open something on my iPad, as soon as I leave it, it was just something else, but.
Well, it had a lot of infrastructure out in Sherman Hills. I remember that.
Well, there is a map. I was just looking at it. Cause it shows sewer and water. So it's map 2, Laramie growth area, water and sewer system. The sewer is labeled a green color and they have it going all out there. Right up to the edge, I thought, unless I'm looking at another neighborhood. It looks to me like it's right near the interchange of the highway.
Yeah.
Which would put it all.
Only into the very first streets.
Well, that's where it's densely populated. I mean, that makes sense to put it there.
Yeah, but
That's
they
where,
put the water all the way up, so.
those are their water tanks. I think.
Yeah.
Anyway, it doesn't matter.
Okay,
But anyway, I guess I just thought one of the goals of this was to create the opportunity to bring people in without forcing them to annex into the city. Because that's the only way you're gonna reach that community. They don't wanna be annexed into the city. But they probably, as leach fields fail, and we're gonna see that as a domino thing soon, there could be pressure from that community to want to get sewer without annexing. I mean, and it's what's threatening the city well. So I mean, if there was a place for the city to be willing to give in, it seems like it would protect their own water supply well to be willing to annex that area. Or I mean, not annex, but extend sewer.
Yeah, I mean, the county may have an interest in that, but it's not a party to any of that. you know?
No, but I think we have an interest in seeing that ability get put into this IGA. Like looking at the one for Gunnison with, I can't remember what town that is. They had the same kind of thing, like extending without annexing. And they say they would consider extending their sewer if it's an area suitable for urban development, or when the extension is necessary to resolve water quality problems. So, I mean, I know we're not Gunnison County, but I think they probably have parallel conflict between their incorporated areas and the county area. And they managed to get their town to say they would extend the sewer without requiring annexation if there were water quality problems to resolve. I want our city of Laramie to be the same way.
And we could do that through the IGA. Again, I guess I'm coming back to, is that a city thing?
Well, right now.
I'd like to see the city extend sewer into Laramie Plains. I mean, that's the most obvious place.
Right.
But we don't have any role to play there, do we, or can we? I don't see.
No, I think it's just trying to have the city commit that they will consider extending without annexing to these areas.
That was a very contentious point.
Yeah, I can tell because you feel like you really had to arm wrestle to get what you got, and then you got 73 pages of nebulous WDEQ regulations.
And it came up.
Okay.
I mean,
So it does, I mean, it questions the prudence of the IGA.
Yeah. I mean, the whole thing then is up in here. All right, let's change the subject slightly to another.
Mr. Chairman, I may make a
Yes.
point.
Yes, please.
I would like to remind all of us that we are working towards a common goal. And this is necessarily not going to be a symmetric agreement. The county doesn't grow in the city grows in the county, and that shapes things in a very fundamental way that we have to keep in mind. This is basically to prepare the ground so that the city can expand in a logical manner over time. And that is the fundamental point of this. I mean, that's what David said, that's what Matt says, and that's what I'm saying now too. And as a practical matter, I mean, it'd be great if the city could expand water and sewer service throughout the entire county, but the problem is money. So without money, and I don't know that the city's got the money, the city is not going to be providing sewer and water outside of the annex boundaries, in my opinion. I could be wrong. And with that, thank you, Mr. Chairman.
You know, just respond briefly to that, and then we're not going to resolve this. But I think Ms. Hanning is identified correctly in terms of the aquifer, something that we've all paid a lot of attention to. That picture is changing, and as systems come up for placement, those financial incentives break in different ways to where some of those densest parts of the county adjacent to the city may find it in their financial interests to bring in sewer. That's kind of where you were headed, as I heard it. And so that's a partial address to the money question. But I don't know that I see a home for that in the IGA. But let me ask Mr. Ayers, say a different question. Contiguous and adjacent. Tell me about that, if you would, please. Are those different? Are they the same? Why are they both listed here? What are we talking?
Oh boy. Man, if you had asked me that like 2 months ago.
You gave us a lesson on it, I think.
Yeah.
All right. So good in my case, I guess.
Okay, so they are different QT.
I mean, and let me jump ahead a little bit. My concern there, and I actually have worked up an example of this, is that one could simply step back from the city boundary increment and thereby not be contiguous and escape any of this.
So what? I'm sorry.
Well, okay, I'm
Could
just
you
saying,
repeat that?
if contiguous with or adjacent, I read those two as the same, unless you tell me adjacent means within 200 feet or something. I'm reading this as a developer who's resistant to it and wondering what my options are and thinking, do I just have to avoid touching the city?
Okay, let me. In order to get to that, I need to find the Wyoming statute.
I guess whoever wrote it must have thought those two were.
They're different, they mean
Something like
different
that.
things.
I thought you said before adjacent meant touching.
No, contiguous. Contiguous is connected or touching, adjacent means lying near or close,
So
but
across
not
the
necessarily
line.
touching.
Now, I think you gave an example of the other side of the road.
Yes, yeah,
Okay, but close, like the other side of the road, not close like 1,000 feet or something.
well,
Okay.
I mean,
It's not
depends on-
completely clear.
so I know that, like, there's, I think it's either in statute or case law, which I do not purport to be an expert on the city's statutes, but, you know, like a lake, large lake may not interrupt a contiguous,
Okay.
like a natural feature, may not interrupt contiguous, even if it is somewhat sizable. They're certainly not adjacent.
Well, what was the meaning of this? What did you guys think it meant?
That's what I'm trying
Next to the city,
Touching?
pretty much. That's what I thought, I guess. But
So the statute for, I'm trying to find it. My Westlaw is not working right now.
and ultimately, there is the statutory requirements for the city to even annex. And so they have to meet those
And-
statutory requirements.
It requires,
And I'm wondering, maybe that's where that language came from. But I'm not sure.
Well, right, let's assume it means either touching or being near touching. That seems to me to be inconsistent with the notion of the LGA, and that one wants to reach an increment away from the city that's likely to be subject to growth within the planning horizon.
Right.
So if all this did was, if it committed the city to extending water sewer, and a developer wanted to escape that restriction, it would seem to be a pretty simple matter to just bring their subdivision within 50 feet of the city boundary and stop.
Well, it'd have to do with their zoning. That's how we would implement it.
Okay.
So like,
oh,
Right, I was looking at a particular tract out there on North 9th where we had the developer, I can't recall his name, who was saying, I don't want anything to do with the city. And we had a little piece that escaped contiguity by one lot. And that was very important to this developer because then he didn't have to play ball. Okay, there's a very large piece just north of that I was looking at thinking, okay, how would I do this? And it's under ag zoning. So if I came to the city and said, I want to peel off the north, well, it's a huge piece. I could peel off the north 85% of it. And I want to turn that into a rural subdivision. And I'm going to leave that little strip ag. That would be an acceptable subdivision of land. And
if the zoning lines up,
well, let's say this piece is currently zoned ag, and he would come in and say, I want to take the north piece of part of it and turn it into subdivision. And then we would proceed to decide whether that was consistent with the planning and so forth.
Right.
But my point is that then if one simply left the southern chunk as ag, then they would escape any implications of the growth area plan or any obligation of the city or any ability of us to say, oh, you have to put in small lots.
It would have to adhere to the zoning of the overlap though, of the overlay, I mean.
Okay, if the, yeah, depending what our overlay zoning looks like, and we're back to, that seems to me that's a whole different kettle of fish that we've snuck around the edges of, that I'm picturing a map of the overlay that we would say, you can't do that because it's inconsistent with this overlay.
That's the whole
Okay.
point of the overlay.
That's what I would think is the whole point of the overlay, but then again, the T or
Yeah,
internet connection that you have to connect. So the city has to agree within the overlay to bring in the water and sewer, which they
That
don't.
one parcel you're talking about has multifamily, industrial, community commercial, and urban single family. So it have to meet those.
Yeah.
And if it doesn't, then you
Okay,
deny it.
what were you gonna say, Ms. Hanning?
Well, what if you took section 7.3.1 about connections, where it's talking about being contiguous with or adjacent to the city boundary? What about if that also said or was contiguous or adjacent with city utilities? Because like where we're talking about right now, sewer and water run down Asphalt Lane. That's, I think, in the county, isn't it?
Mhm.
But, so there's like city land, intervening, county land. Then there's a city utility going out to their new, well, to the wastewater treatment plant and to the new facilities on Third Street. So you have infrastructure right there that could easily go up onto that ag parcel. If you broadened 7.3.1 to include being contiguous or adjacent to city utilities.
Um,
Because it's really about being able to, you're trying to reduce the cost to connect to.
So,
to
so what
sewer.
what this says right now is that basically if you are not in the second, or if you are not kind of in the first, we've been calling them rings. You know, there's the ring, there's the first ring, second ring, you know, however many to fill out the entire LGAP. What this says is that the county will only require connections to municipal water and sewer for subdivision in the first ring.
Even if there is utilities going to the third ring and part of the county. Which is what,
Yeah, I mean, I don't think there is.
Okay. And even if that first ring is 30 feet.
Hmm.
Okay, that's what I read. That seems contrary to what we thought we were doing here.
Yeah.
Okay, this was a discussion section. You heard a lot, I guess. Go
Yeah, but minor thing.
ahead. No, let's
Shouldn't be
give them the whole
controversial.
one.
With 6.2 and 6.3, where the city and county are both talking about how they're gonna let each other know about applications. Would it make things more efficient to be notifying each other at the pre-application meeting stage as a, like, just to give a heads up? Even though you haven't gotten a formal application in yet, like, is there any benefit to preventing miscommunication or getting too far down a road before you know what the other party thinks?
I mean, I think we have discussed that. I think my thoughts we're just gonna put that in our zoning resolution and the subdivision resolution where it says that we'll invite them to be a part of these pre-application conferences. Especially when it comes to subdivision, because it's, you know, if there's a subdivision and it's right next to the city, then they're probably gonna need water and sewer, which means they're gonna need to go to the city anyways. And so we would want to have them in the room, you know. And I think, you know, I don't know if the city's even gonna care if it's like, you know, way south of town or whatever.
I think
But we can talk.
It said that originally, that we were,
Did it?
we were gonna meet all of us on every single zoning change or whatever. and they didn't want to be notified on like the ones that were like out there, you know? It's like-
Yeah.
Okay.
I mean, we would still let them know, obviously, because they're within the the growth area, they're within the 1 mile. And so, I mean, they would still know about it. It's just that they don't necessarily want to be in the meeting every time.
Yeah, and I apologize because I know we've wrote some of this language out, but was it in here or was it in the zoning? Or
Right,
like,
right.
so, but all these things have been talked about, but that is a good point. That's just not what we ended up with
Gotcha.
this. So.
Well, I've exhausted my notes.
So what's the next step? I mean, if we were being invited to endorse this to the county commission today, I think it probably wouldn't happen.
Well, I mean, you guys
And
can
then we
vote
don't-
on it.
and
You
we
can
don't-
make a vote and say, I mean, we've looked at these things and these are our issues with it and we wouldn't support it. I mean, you can send a recommendation.
So what's staff recommendation on this item? Would you like to see, are you recommending that we commend this to the board? Or are you
Honestly,
still
it's up
working
to
on
you
it?
guys at this point.
But you're already moving ahead on regulations that would implement the LGAP.
Yeah, I mean, we would recommend approval. This is something that we've been hashing out. And it's what we've came up with. Like I said, I feel like it's more just pointing us in the right direction. We're leaving the plan to be the plan. The plan's gonna guide all the big stuff, but this is just to really get us communicating. And so we would recommend that you recommend it to the board, or you know, if there are where they don't really need your recommendation, if you have specific comments, if you want to list them out and give them to us or whatever, we'll take them to them and say, these are our issues. Because then at that point, they might say, yeah, those are good points. We want to negotiate with the city on these things. So I guess that's where I would leave it with you. We would recommend approval, but we would also recommend you provide us with your comments, like specific points that you would like us to take to them.
So, I mean, is that tractable? I don't think we're gonna fashion them on the spot. Are you suggesting we individually provide you articulated comments? Is that kind of what you're envisioning there?
I was like, if you could put what you guys have just discussed into like succinct comments, that's what we, you know.
Okay.
You're welcome to reach out to me afterwards, I guess, with specific comments from you individually, but then it wouldn't be necessarily be coming from you guys as the board. If I get them individually, it's from you as individuals.
Well,
Yeah, but still, individual commissioners, but it's not any of you speaking on behalf of the planning and zoning commission as a whole.
Well, I'm a big believer in putting things in words. It just creates the discipline to make everything fit together, but I don't think we do that on the spot. So either we as individuals provide you our comments written down, or we try to collaborate on a group document, but takes time. So how do we proceed? Does one of us draft what we think we just heard up and we circulate that amongst ourselves, or get to you guys?
I mean, if you wanted to draft something, we'd probably have to schedule a special meeting for it to get approved.
If it was gonna be a
We
joint
would
statement.
absolutely have to.
Yeah, I mean, our plan is to take this to the board in February to stay in track with the city, but I guess
Has this gone to city planning yet?
it's supposed to be going this month, I think, sometime, so.
So we don't know if they're gonna have a similar reaction of like, we expected something different.
We want to get.
Yeah,
more.
I don't know what
Yeah.
What would more look like? What would that even, you guys have been in this give and take. Tell me, what is the give and the take? What
Sewer extension.
Guarantee water and sewer for
We give
everything.
the subject. Oh, no. I'm just joking.
what is the city? What if they were just written that you guys hadn't have anything to do with it? They just said, here's what we want. How would it have looked different than this?
Yeah, it did. It said county's gonna do everything and we're gonna do nothing.
do everything.
There was a lot more stuff that the county was supposed to do. I mean, the only thing we really wanted was the opportunity for them to extend city and not require require annexation with it.
So the city wanted to write zoning for us?
They wanted us
No.
to do stuff with zoning certificates, conditional uses.
They wanted everything that came through our
They wanted
office that had to
anything.
do zoning to come to them, which, I mean, that just seems like a lot.
For
And I don't know.
comment or approval or?
Yeah,
To
so
take
like if
over.
there's a zoning certificate for a house, they wanted to go to them, basically. That's how they had it originally written.
Okay, so that the city would simply take over zoning through the growth area.
I mean, it would still be us, I think, that approves it, because we can't give up that authority. Only the county has authority to approve
Okay.
zoning.
The county planning office
They wanted to be
doing all the
able to,
work for the.
Yeah.
yeah, comment and provide.
I wonder if the approach was how I feel about this. It,
No, there was no sentiment that they didn't think it was
and-
robust enough.
And my vision, which is obviously different from everybody else involved, it's basically we take responsibility to plan the growth of the city within the county based on what the city likes, but doesn't tell us. That's what they're asking us to do.
That was nicely said.
That's exactly what they're asking us to do, and I have a problem with this. I don't feel that I can deny or approve anything if I don't know what they want. Right? I think that's their vision is what I envision in this process. Okay? And we made them back off.
All right, so let's back to,
Because of, I understand why you made them back off, but on the
So-
other hand,
what can we do that's helpful to this process?
Why don't you guys, if you have individual comments, get them to me by,
January 23rd.
yeah, January 23rd. That'll be the easiest. And that'll get, they'll have an idea of what you guys want, and if your ideas overlap, then they'll be fine.
I mean, then you can condense those or because that's what you're gonna have to do. Otherwise, if we just walk out of here, you're gonna say, well, here's what
Yes.
these guys said. It's
Yeah.
best you can determine.
Right, yeah. I'll condense those into something that can.
Are we willing to try it?
Do you think we can just pull off like conditioning our support of this right now?
Again, I'd like to see words on a page. You got some? I mean, what would we say? I think we're all kind of have different ideas, and Mr. Platt, you're welcome to weigh in. You seem to be one of the most favorable to just say, go for it.
Well,
David?
in fact, Mr. Chairman, that is what I would recommend. It has taken us a long, and when I say us, I mean the city and the county, not just the county, a long time to get here. And David has said repeatedly, and I agree with him, this is a broad vision, broad brushstrokes for laying out the ground for the city to plan to grow in. And the county and the city, sat down and jointly arrived at this map. It wasn't just the city, it wasn't just the county, it wasn't just the consultants we had. And this is the map that was agreed upon, and now it's time to start implementing it. And this is the first step. It's not perfect, but if it moves us forward in the right direction, I think that's the right thing to do. It's good for me, and I think we should be moving. It would probably take us forever to come up with something we might all mostly agree with, and then we'd have to go back to the city. And that would be another forever.
Okay, thank you. If you would like to make that a motion, we can vote on it, but my sense of the commission is that it would not capture the majority. But what say my colleagues?
Well, I guess I think there could just be some simple recommended amendments to the IGA.
Doesn't even have to be like text amendments, it could just be conceptually,
Ideas.
like, this is what we would prefer to see out of this.
I mean, I would suggest that section 7.3.1 should include the idea of being contiguous or adjacent to city utilities as well as the boundary.
Or it would just be, well, is there any part of the city that isn't on city sewer and water?
No, there's utilities in the county outside of the city and away from the city boundary.
There are two places, right? Very.
But it's right next to a really large parcel that.
Yeah. So, yeah, I mean, I think that
So-
then it would just be replacement of boundary with utilities.
Or, yeah, I guess I see what you mean.
Yeah.
It's probably city sewer anywhere, right? Okay, that works for me. And then in 7.3.2 extension, I would just recommend that in the last sentence, you broaden that out to landowners, not just subdividers. I mean, so that you can contemplate existing subdivisions. And I would recommend that, city's criteria for that. In that same sentence, the city shall allow extraterritorial extension of water and sewer services to properties ineligible for annexation when the criteria is satisfied, including when an extension is necessary to resolve water quality problems. I don't know how to get in the idea that, I mean, I guess maybe what you've been telling me all along is this doesn't belong here, that's like another problem. It's not about growth, it's about existing subdivisions that I'm trying to get to through the IGA, and maybe that's not the right vehicle. So maybe just those two proposed changes.
I mean, I think it could be, but I don't.
So
It's
I'd
not
be,
very practical.
no, maybe not. So I guess that's another, has nothing to do with future growth. So I guess it doesn't really belong here. But if we just took 7.3.1 and made it be utilities instead of the city boundary, and if we just took 7.3.2 and broadened the decision to the subdivider, or, I mean, maybe it's just the single lot homeowner who wants to annex and get hooked on.
That you want them to commit to allowing them to do that?
Or I guess it's saying that an individual homeowner could have the opportunity to request it.
I think you're right, the word subdivider is misleading here. It shouldn't be subdivider, it should be the landowner. That takes care of all the different categories.
Yeah, that would work for me, but I don't know if there's something you guys were thinking of when we were
Yeah,
talking about subdividers.
so, I mean, the approach to this is that the extension of municipal services is upon subdivision. Not just
Just on request.
building a
Yeah.
house, because I mean, and that's just annexation. You know, the city or a landowner can start that petition.
Yeah, I mean, these are regulations that we have that we can deal with. Like, if there's a landowner that wants to annex within the city, they don't come to us at all. We
Right.
don't even
I
talk.
don't hear about it.
They
Yeah.
go and petition the city to annex.
So, yeah, we only hear about it if they're trying to de.
Right. We've done.
Which happens.
Okay, Uncle.
Well, I mean, to say that, so I've got a sewer line that runs past you. It doesn't, there may be good reasons why. It's totally at capacity. It just seems like that tying it
Well, I guess
to,
they're
tying it to
gonna-
the existing line of a water sewer doesn't.
They're gonna deny you under this chapter 10 of the WDEQ rules, right? That they can't, like,
Safely.
that trunk line can't handle any more flow,
Right. I mean, there are legitimate reasons.
right, to not hook people up.
Right. I would like to see just a much stronger commitment to we're going to make that happen, whether it's running a new line or hooking you to an existing line. I mean, that should be much broader and more open. I just don't see that this does what we want to do, because the city just decides whether they want to extend it or not, and they can do that any day of the week. They get to. We have no control over what they decide to annex.
I mean, we're kind of in a hard spot though. Like, how do we tell them you have to allow water and sewer? Like, and they come back and say, well, in order to do that, we have to build a new tank. We have to build a new facility to do this and that. Like, so, I mean, I understand why the city wants a little bit of wiggle room there, because like, we can't tell them, you have enough, capacity to even do this. We can't, I mean, and that needs to be something we think about too, but I don't know, like, how do we reword it to?
But they've also agreed with the plan, so you would think that they would want to do what it says. At some point, they're gonna have to put their money in their mouth.
Well,
I mean, and I get it too, because like, I don't know, somebody comes in and they meet these criteria. I mean, the city just has to write us a report saying this is why we're denying it. I mean,
I get it.
I don't know.
We've fought over this. I mean,
And maybe that's right, in which case then it's the city's show.
Sure.
And what they're saying to us is, if we agree to run water sewer out there, you, the county, will require that of your subdividers. Maybe that's the way to condense what this thing all down. That's what we're trying, this does. It leaves it in the city's lap. We've agreed that if they will agree to run water sewer, we will require that of our subdivider. That's the point, I think.
Right.
Okay. And if that's the point, then it should be over some distance beyond just abutting. So I guess that'd be my comment, is I'd like to see it say, how far are we willing to require it of a subdivider if the city says they'll do it? Because we're the heavies on this thing when somebody does this with the subdivision. And I think that's more than touching.
Right.
Okay, so I don't know, do we leave it at that and you wrap
so
your
Bert,
minds around?
you're suggesting take out,
Well, I don't know what it would look like.
take out,
Words, but it's the adjacent.
that is contiguous with or adjacent to the city's boundary.
Yeah,
yeah, it would be 2 spots.
You would just take
Um,
to the unincorporated area of the LGA
well,
that,
yeah, maybe that'd be it. If there's a chunk of.
unless the city determines not to pursue.
Yeah, I mean, that's,
Well, can it be the areas in the LGAP map too, where they show where they've thought about running sewer and water? I mean, can't you just say all the things on this map that you already put in the
They come-
LGAP?
can you bring that map up for us, guys?
They can't pay for this.
well,
Well,
yeah,
but-
because you go to like one of the last few pages of the growth plan. If I can find it.
Can you guys see
Yeah.
the greens and the blues?
Currently, the city is hesitant to extend city water and sewer services beyond the city boundary without concurrent annexation. But the density and intensity proposed adjacent to the city cannot be served by individual well and septics. Therefore, to transition to the development pattern shown in the plan, the city will need to consider revisions to city policies about out-of-city service extensions.
Right. And that's what this LGA is that revision to city procedures, right? Okay.
So it would need to say, city shall require connections to municipal water and sewer for subdivision in the unincorporated the LGA that is contiguous with or adjacent to the city's boundary, or that the city has determined it is able to extend water and sewer services at that time.
Something like that. And you're drafting out loud, or are you reading from something?
I'm drafting out.
Okay, I like that. That seems to me to be the spirit of this whole thing. So somebody comes in with a big subdivision proposal to us, and it's 100 yards north of the city boundary. And then we go to the city to say, are you willing to bring water and sewer to them? And the city says yes. And then we say to the developer, okay, we're going to approve it, but we're going to require water and sewer.
Well, I think 100 yards would certainly qualify as contiguous.
Well, or whatever the number is. You think that would be adjacent?
No,
Because that's
so
more than across the street.
100 yards. I mean, that's.
Well, that's more than any street in town, but I mean, I just pull that out of
Oh,
the air.
sorry. So I mean, yeah, that would certainly. I think that's adjacent. Yeah, line near close, but not necessarily touching.
Okay, 200 yards. Where would your nerve break?
Or mine. I mean, for this.
I mean, okay, there's my input. That needs to be. It needs to reach out a ways. That's the whole point.
Yeah.
Now, if it was the entire LGA, what would that look like? Then the city would come back and say, there's just no way in the world that we could take water and sewer out to these guys. How fat's the LGA?
Well, the other thing is that entire extension, the city's not going to be paying for. The developer is. The city has made that abundantly clear. They're not.
That's
Right.
out of the business for sure.
Right. But so it would have to be within some feasible, so it wasn't just, you're gonna build a pipeline to the moon, right? We would have to have some sense that this is a feasible demand of our developer.
I mean, if the developer's gonna pay for it.
I mean, again, that gets back to the way developer pays for it is by selling it off in city density lots, which is what we're after. And otherwise, how do you get the developer to put it into city-sized lots? You can't demand that nobody can buy more than one lot and put a house on that whole thing. It seems to be your only tool is the economic. So what is the city's answer to how do we do this? Again, what would they have the county do? We all agree that we want to have a coherent plan and that's going to require some disincentives as well as incentives. All right, were you prepared to commend this forward with heading based on those small changes?
Yeah, I guess. I move to recommend we support the IGA with the minor amendments that we're recommending.
Which ones?
Uh,
So
What would you just
we
say?
had the add essentially a standard in 7.3.1 for not necessarily contiguous with or adjacent to, but any portion there are within that the city determines
City
it will extend.
utility corridor.
Or do you want to go based, see, but, so are you still wanting to go based on that proposed map of service extensions in the LGAP?
I guess that, well, some of it is not proposed, it's done now.
She was talking about existing utilities that are out in the county.
Well, but then Burn went beyond
Farther,
just.
yeah.
Right, so probably wanna go with one or the
Sorry.
I
other.
don't know
Yeah.
that one. I mean, that the city should be willing to contemplate the areas already delineated in map 2 in the LGAP. Cause they're not gonna pay for the extension.
I mean, could you say like, go with Burr's idea and if not willing, Morris?
Well, I think
I mean, I think you, I almost think you take a.
Burns idea,
all of it.
or Burns proposal would encapsulate Mars.
Right, that's why I said,
Yeah.
So how do we word Burns?
So, I mean, I think what I had, the county shall require connections to municipal water and sewer services for subdivisions, or for subdivision in the incorporated area, the LGA. Which the city determines extension of water and sewer services are feasible at that time.
There, that's what I was trying to say. Thank you.
That works.
Can you pull that from the recording?
I ain't writing it.
We can.
All right, well, that, I guess that's brings the teeth to bear on what I think needs chewed.
Here, I'll
Okay, was there a
Okay, so
motion
I
in
make
there?
a motion with
Do that.
those two, with that change that you'll get from the recording.
All right.
I'll
this
second
is-
that.
This is a kind of an informal motion since we aren't. But all right, I think it's
Platt
coherent at
seconded-
least to me.
Mr. Platt just seconded it.
Okay. Is somebody clear on what that is? And I like the words that I heard from Mr. Ayers.
Yeah, we'll take care of it.
Okay,
Yeah.
then
Better.
discussion of that motion. So what would happen here? Let's just see. Is this would go to the board for their potential approval? Well, I guess we'd go back to the city, whether they would say, no way in the world this is gonna happen. Then we're back in negotiations.
Well, go to the
I think
board
we'll go to the
first,
board
and
and
then
they
the
would
board
make- they
will
would make the
determine
request.
whether they want to do anything else.
Okay, and the board will be presented the thing as we received it along with our,
We'll provide your comments to them.
gotcha, okay, all right. I can go along with that. We have the mover in the second, Ms. David, how's that strike you? Useful,
Nothing to it.
nothing to add. All right, then let us take that motion to a vote. Ms. Hanning,
Aye.
Mr. Platt,
Aye.
Ms. Ben David,
Aye.
Hinckley, aye. Thank you. I will.
So a rhetorical question, if the county commissioners decide they don't want to be party to this IGA no matter what it says, then we're still able to go forward with zoning ordinance changes that reflect the LGA.
I mean, this board can, or planning zoning commission can recommend what they want to them, so, yeah. I don't know. I mean, I think we'll get a feel for what they want with the community growth area plan. It may not be worth our while to do that, but I mean, you are the planning and zoning commission, you do start the process of regulation changes, those types of things, so we can move forward if that's the desire of this board, but we also, I think, wanna take into account what they're thinking too. Cause
Yes.
I don't want to waste a whole lot of time.
Yeah,
No, I-
no, we
no, I-
gotta have our priorities in alignment.
No, there's no point wasting anybody's time, so I think that feedback will be valuable, assuming that were positive. It was the county commission that approved the original plan, that our next steps would be to start working with Dover. Yeah, it would be the logical progression. Okay. All right, end of that discussion. We'll wrap this up. We're looking for a couple of staff updates. I think those are pretty
Yeah,
straightforward.
so both of the updates are the aquifer protection regulations that went through the process. One was the zoning resolution, which was approved. So the new aquifer protection overlay zone resolutions with all the updates that we've made are on the books now. The other set of regulations were the wastewater regulations, and they were also approved. So those two sets of regulations, I believe it was December 7th, the hearing was held, and they were approved by the board, so they're on the books. So that's all I had for updates that I could think of.
So I was just going to add on that last point that recently DEQ released a report on its investigations of septic systems and nitrate issues in the Hillback Junction area. So there are other places in the state where it's been recognized that high densities of septic systems have created groundwater contamination in DEQ and either Teton or Lincoln County, wherever Hillback falls, are working forward to resolve those issues. So we're not alone in the concerns and the approach that was taken in those wastewater regs. Okay, then our third item was the meeting dates.
So the way I have it, I just kept it the same, second Wednesday of the month, 5 PM. If you guys want to discuss that, you can. And I have the actual dates available to read off if you want me to read them.
Were the deviating from second Wednesdays anywhere?
No.
Okay, how do folks feel about that? I'm okay with what we've been doing, both the time and the dates, but we can sure change those. People have other obligations.
I just have one question. So March meeting will be on the 12th?
Yep.
Okay.
Mr. Platt, any thoughts on, would you prefer a different meeting time or date?
This is fine for me.
We're all gonna have conflicts as they come up, but I don't know of any in my case. Sandy?
It looks like that schedule wouldn't be in conflict with the school district time off schedule.
Spring break.
It's the week after.
Week after?
Last year, I think it was the same, this time around.
One of the milestones in parenthood is becoming free of the Albany County School District schedule.
I remember back when I didn't care about that, except not to go certain wonderful places when everyone was on spring break.
Oh, okay, do we need a formal adoption of those?
Yes.
Actually, only for the time. The bylaws state PZC shall hold regular meetings on the second Wednesday of each month unless rescheduled. So,
Okay,
So set the time for the next year, including January of 2026.
open to a motion.
I move that we adopt the schedule of meeting based on second Wednesday of each month
At what time?
at 5 PM.
Is there a second?
I'll second.
Oh, I'll let Michael second.
Seconded, discussion of the motion. All in favor, say aye.
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 Opposed, same sign. It's unanimous. Thank you. Commissioner comments. The only comment I wanted to throw in was that at our February meeting, we will be electing a new chair and vice chair. I'm term limited out, so I don't have to think about it. And we'll do that immediately following disclosures and conflict of interests which point we will have a new chair and they can take it from there. So keep that in mind as we approach February. Anybody else have anything they want to add? Okay, next meeting will be February 12th.